Right. Yeah, awesome. At least a clock. All rise. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Morris Silverman, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning, everyone, and welcome to this session of the Second District Court of Appeal. I am happy to be joined today by Judges LaRose and Lucas, We are streaming, as you already know, so just keep that in mind. We had a show cause scheduled for today, which appears is not going to happen. I'm assuming, since he said he's on the road, that Mr. Kolb is not here. I just want to confirm that, and he is not. So we will proceed with the cases. There are 4 scheduled on the oral argument docket, and we will take them in the order on the docket. A reminder to those of you who are representing or acting as the appellant, you can reserve up to 5 minutes of time for rebuttal. If you let me know at the beginning of your argument that you wish to reserve that time, I will let you know when you get to that point in your argument. And of course, you can continue forward or sit down and have the 5 minutes for rebuttal or whatever amount you choose, that or less. With that, the first case on the docket is Mr. Sethi versus Chapel Pines Homeowners Association. We are ready when counsel is.
Good morning, Your Honor. May it please the court. My name is Scott Haas. I'm here for the appellant Sandeep Sethi. And Your Honor, I would like to reserve 5 minutes for rebuttal, please.
Very good, Mr. Haas. One question, I might as well ask you both. There is a cross appeal. So the question I have really directed to the other side. Are you going to argue everything in your answer, or do you anticipate wanting to reserve any time to rebut on the cross appeal?
Please, the court, Your Honor, we would prefer to argue everything all at once if the court is so inclined.
All right, so you will have your initial argument. Go ahead and address whatever you wish to as far as the cross appeal as well, or you can argue that in your reply or your rebuttal time, and then you'll just have your 20-minute for your argument after he finishes his initial. Does that sound good?
Yes, Your Honor.
All right, thank you.
So it'll be 15 and then I can save 5.
5. If you want to, because of the cross appeal, if you want to reserve a little bit more than 5, you may do so. So I'll leave that up to you. But you know, the cross appeal, I think, is fairly focused on what the issue is.
Thank you. Your Honors, thank you for this opportunity for oral argument. My client and I very much appreciate it. Mr. Sandeep Sethi, the appellant, is the owner of the property in Chapel Pines development. Now, he became owner first in November of 2017 by virtue of a certificate of title that was given to him by the clerk of court as a result of his purchase at a foreclosure sale by the association. So the association had a pending case going back prior to 2014. They got an amended final judgment in 2014. The case sat there for a while, apparently because of the prior owner's bankruptcy issues and so forth. The HOA set the sale date back in September for October of 2017, had the sale, did not ask for more fees at the time. So there was an award of attorney's fees in that HOA foreclosure judgment. My client was the winning bidder, paid the entire judgment amount plus a surplus of about $7,000. My client also purchased the same property again at a senior foreclosure sale in 2019. I call that the Wilmington senior foreclosure sale in the briefs. Your Honor, 5 years ago, more than 5 years ago, we had an initial hearing on a motion to dismiss where my client raised the declaration. The declaration is a contract that is not to be impaired by a statute. It's a constitutional issue if that is the case. At that hearing before Judge Sestak, which then retired, my client, through me, raised the declaration as an issue in the motion to dismiss based upon count 2 for damages. In count 2, in the complaint, they being the HOA, sought all the prior owners' assessments, attorney's fees, interest, and costs against Mr. Sethi. Now, that was wrong according to the declaration, and I raised it. And in the brief is noted, it's in the transcript from that August 2018 hearing. Opposing counsel for the HOA said you can raise that defense later. in an answer, which we did. Your Honor, this is a 2001 declaration, which has some clear terms. Liability shall not pass to a successor owner. So the liability of Mr.
Mr.
Lutzker.
Ross, maybe I can short circuit this a
Sure.
little bit, because ultimately they conceded that they weren't entitled to it, or they waived it, depending on how you want to interpret it. But ultimately, they did not ask at the final call of this case. They did not ask for those amounts.
Yes, thank you, Your Honor, for pointing that out. And that is a big issue because essentially they made a seismic shift, a case shift in their whole position in November of 2017, before the ink dried on my client's certificate of title. The HOA, through its counsel, sent a demand for $10,000 plus $9,000, I believe, of which was attorney's fees. Yes, they did concede it at the summary judgment hearing in June of 2020. The whole reason why we were there at that point is because we had the defenses and said, you can't do that. It wasn't until the actual hearing that they conceded, and the court accepted that concession. But in essence, that's the Augustine case. They were using the Augustine case, saying that there was a confession of judgment by my client. A confession of judgment in the Augustine case talks about paying what was pleaded. What was pleaded in the amended complaint was all the prior owners, 2014, 2015, 2016. So in essence, they conceded that there should be a judgment for SETI on that defense. This case, Your Honor, and nobody wants to be here 5 years later, but the fact is we had a summary judgment where we had defenses raised all throughout the proceeding. They didn't meet their burden. They eventually
Most of
conceded.
your defenses were related to the foreclosure, though, correct?
No, Your Honor, it was
Well,
related.
I read the defenses. The first 3 or 4 specifically say defense as to the foreclosure. And that's not the wording, but it talks very specifically about in the foreclosure. Let me see if I can find it real quick, because I made some notes about that because I was concerned about that. So the first one, given that foreclosures are matters of equity, it would be inequitable. Paragraph 29, plaintiff is stopped from seeking foreclosure on an alleged lien. Paragraph 30 is stopped from foreclosure. 31, anticipatory breach, that is not limited to the foreclosure.
Okay.
32, improperly rejected, that's not limited to the foreclosure. And the same with, I think, 33 and 34. So it looks like the first 3 or 4 are foreclosure defenses.
Yes, Your Honor, that's fair to say, correct.
Okay.
I'm sorry. Yes, 4, 5, and 6, I believe, are those that I'm really referring to, the defenses to the damages count. Because later on in this matter, there was the Wilmington foreclosure, which was a senior foreclosure, and by virtue of the sale, the lien was extinguished as a matter of law. So
The lien would have been extinguished as to anything the prior owner that might have been claimed arising out of the prior owner's ownership. It would not extinguish the foreclosure to the extent that your client had not timely paid an assessment, correct?
the foreclosure would, by the second one, the senior foreclosure would take away, in essence, the HOA's claim for assessments up to that foreclosure, most of which was the prior owners.
I'm not sure I understand that. Why would that eliminate their ability to foreclose your client's interest if he owed money to them?
Well, the main argument, Your Honor, is that it foreclosed out up to the certificate of sale / title, which came 10 days later when the sale was confirmed by no objections. But just by the language in that Wilmington judgment, which I believe is
I mean, everybody conceded, so I don't want to spend a lot of time on this. Everybody conceded that the foreclosure by Wilmington mooted out the foreclosure in count one.
Yes.
Okay.
Your Honor, the declaration was clear, not to pass to successor. Owner fell when it matters who the owner was when the assessment fell due. And lastly, it was an annual assessment. So the 2017 assessment was an annual assessment. And who was the owner at that time? Glenn Lutzker. Now, the HOA has made one reference to a prorated, that somehow it was prorated and somehow that we paid it out of good faith equals a confession to judgment. First of all, Your Honor, that prorated language has to do with when there's a first sale of a lot. So that back in 2001, there were many lots and not all the lots sell at the same time. The prorated language, which is only mentioned once, shows up in the first lot provision, first sale of the lot provision.
Your client didn't dispute its willingness to pay those that last half of the 2017 October assessment. I mean, he ultimately tendered it, went into trust, and I don't think that was ever really litigated, was it?
Your Honor, my client did pay the prorated portion of that last one, but we've always argued that that was done in good faith and that if anything.
But your client was still late on the January assessment and the April assessment, correct?
It was not paid, but it wasn't like my client refused to pay.
I understand your client got a letter from them saying you owe more than that, so we're not accepting your payment.
Correct, don't
But
pay.
either way, he didn't tender payment
Correct,
until it was late.
correct. So for those two, January of 2018 and then April of
Is
2018.
there anything in the record to explain that point? And it was just something that had me scratching my head, like, why not tender the payment? And just say, I am hereby tendering, and the association refuses it, they refuse it, and then the chips fall where they fall. But then you've got a tender payment for the amount that ultimately was what was owed. Is there anything in the record that explains why that didn't happen?
Well, my client did tender in May 2018, $187.50. They got it, said they're not going to take it unless they apply it to the hierarchy, which is interest in their attorney's fees first. And so when they contacted me, because I was counsel for Mr. Sethi at the time, I made a good faith letter in June of 2018, right before the SESTAC hearing, the motion to dismiss, where I asked specifically, that's in the record. We want to know what's the interest, what's the attorney's fees, what's the cost, and if there's any administrative late fees attributable to Sethi's ownership. Crickets, nothing, no response. It was eventually sent back to 187. So we did try to pay, my client, I should say, try to pay those that according.
In May, but in May was when that
Correct,
occurred.
correct. And here's the thing, we had already done a motion to dismiss, or we had a motion to dismiss. They had already told us anticipatory in a breach manner saying, don't send us anything.
Yeah, that also kind of raises a question I had, which is, I'll speak candid, I don't understand your anticipatory breach argument.
Okay.
To my mind, it seems like if the association is failing to follow the scheme of 720-3085 sub 3B, then that is simply, it is a failure to do what you're supposed to do under the statute. I can't conceive of how that works. An anticipatory breach, which usually in breach of contract actions means you are excused from further performance. So help me out, help me understand.
Thank you.
How that works.
Thank you. So what I'm saying is we're not arguing that SETI should be excused from paying any assessments. We're saying we shouldn't have to pay what they demanded and said that they wouldn't take anything less. And
So
if
that's just a denial.
no, I think it's more than a defense, because they're saying we're not going to live up to the declaration. We're going to demand things that the declaration says shall not pass.
It was pled the way it was pled.
Okay.
I had a hard time understanding
No,
that.
did I answer that decently?
I think.
Okay.
It sounds more like you're just denying that the way they wanted to proportion fee was correct. And that issue probably could have just been teed up.
Well, it's also, that's a good point, Aaron. It's also not just anticipatory breach, but a misuse of 720-3085. They're saying we must apply anything you pay first to interest, then to attorney's fees. So my client,
Well, I'm not sure that's incorrect, actually. I think what may be incorrect is the effort to apply it to the prior owners. debt.
right,
But it doesn't seem, as I read the statute and the declaration, it doesn't seem to be incorrect that if they had focused solely on what your client owed, that they're going to apply it first to past the attorney's fees, interest, late charges, and then the amount on the assessment.
correct. And that would be the misuse. We understand that if there was a late payment, it should be applied to interest first and then to attorney's fees. So it's the misuse. They're saying we must take it and
Again,
apply
it's
it.
the question as to what does your client owe?
Correct,
Okay.
correct. Your Honor, the summary judgment, which really is the foundation of this whole matter, is the July 2020 judgment. We have a de novo standard of review for that. And in this case, Your Honors, the HOA did not meet its burden. They submitted one affidavit, which talked about October 2017 in their ledger being attributable to Mr. Lutzker. So that whole prorated portion that Mike's client sent in good faith essentially should be applied to interest or whatever that may have accrued, which I then asked for back in June of 2018 for that amount. Your Honor, what happened was my client filed affidavits, raised the defenses. Their affidavit has nothing, says nothing about the defenses, talks about it being, the money is being applied. And the real kicker is that all these trust payments were assessment payments into trust magically by the preparation of the court order, turn those into payments to mere interest and attorney's fees that had to be later. So my client for the past 5 years has been religiously sending in assessment payments, which have been still held in trust. By the way that the judgment is worded, all that money up to the time of the judgment, and I don't know where the money is currently for all those other ones
Well, it's
since.
been reduced to a judgment, so it doesn't appear that that matters anymore if we were to affirm that is done.
Correct, correct. Your Honor, so really what happened, Your Honors, what really happened is the trial court took a side, chose sides, and thereafter kept on choosing the side of the HOA. Yes,
You're at your 15-minute mark.
okay,
I'm going to give you an extra minute or two just in case you want to address the cross appeal.
sure. So the cross appeal, actually, I need to go into the attorney's fees. Just
So you
on
can use,
the
you can use
management.
those couple of minutes however you wish.
I'm sorry, thank you. Attorney's fees. So, Your Honor, Your Honors, they did not meet their burden as the movement for fees. They have to have detailed copious notes. They also have an obligation to prune under cases such as Blanton. In this case, at the day of the evidentiary hearing in September of 2021, they made a maneuver of doing what's called color-coded fees.
Demonstrative, they used to demonstrative basically, right?
No, actually,
To say, we actually are going to go after these fees, we're not going to go after these fees.
yes, but it was after the hearing. I didn't see the highlight until after.
Can
Correct.
you tell me, what is the total amount, like dollars and cents that you believe got overpaid, like that should not have been awarded? What is the final amount? 'Cause this is your issue on appeal, you have the burden of.
Right.
To show us.
Your Honor, I whatever the number is between the lien being extinguished and at most the November
What's
2020.
the amount?
I don't have that calculated, but that's the range that should be followed. through November 2020, because we were
That
at,
puts us in kind of a weird position where you're basically asking us three to put on a green eye shade and act as your accountant to go through this and figure this out and deduct, you know. I guess you're saying whatever the court's discretion feels is deductible, but usually on an appeal where you're the appellant, where you're saying that the trial court worked too much money, that's your burden to lay out for us. These fees, these entries, this amount, these hours need to be reduced for these reasons. And it's hard for, at least speaking for myself, it's hard to work with a range.
I understand, Your Honor. Now, at the hearing, we did have an expert, Matt Wolf, which went through many, and the court actually struck a lot of that was not intertwined. And my concern was that even when we got a small victory, which was no fees on fees, the court then awarded fees for fees. And so that's why, Your Honor, I apologize. I don't have a number. Personally, I think my client should be considered the prevailing party because he understands the $150 issue. But that's what we've always tried to pay. In fact, he tried to pay $187.50, and we get a seismic shift at the judgment hearing. So frankly, and I don't mean this to be rude, Your Honor, but my client should be awarded fees. But if they're going to be, they should at least be.
Mr. Ross, I've let you go over if you're
Okay.
going to reserve your fives now.
Okay. Thank you.
And for the appellee, you'll have 23 minutes to argue if you need that.
May it please the court. My name is Jason Davis, and I represent the appellee cross appellant in this matter, Chapel Pines Homeowners Association, in the appeal of 3 separate orders to this court, a separate consolidated case in this number. 2 of them deal with the final summary judgment entered in this matter, February 24th, 2021, a separate order, February 24th, 2021, denying Mr. Seppi's request for judgment on count 1 of the lien. And then the final order is the fee judgment for the attorney fees and costs awarded to Chapel Pines.
Mr. Davis, the first thing I'd like you to address, what was the basis of the association's claim that it could seek from Mr. Sethi any monies owed by the prior owner?
Your Honor, and I think you hit on this, was the in rem amounts that the association could seek. In Chapel Pines,
How could they seek after the foreclosure against the prior owner any money from the new owner?
an
Didn't it
interesting,
merge into the final judgment of foreclosure against the first owner?
it did not, Your Honor. The judgment of foreclosure against the first owner had a delineated date that included the assessment amount, interest, attorney's fees
So you
through that date.
You could have sought modification on that, right?
I believe there was some talk that you could seek an amendment to the final judgment. I take a different view that you cannot amend a final judgment after a certain time period. It has to be appealed if there's an error in it. I know that there has been a practice where.
So if your client felt that the prior owner was uncollectible, would it be entitled and allowed to narrow the amount it claimed from the prior owner and reserve to go after that amount against the successor owner?
So I believe that the association is entitled to proceed against both owners on an in rem basis. Again,
Give me authority for that, because I didn't really see anything in your brief that justified what the association demanded from Mr. Sethi.
yes, Your Honor. I think the problem, and you're likely not. I don't recall it being in the brief because that's not the judgment we're on appeal on. We're here on the personal damages.
We're here on an appeal involving a claim against Mr. Sethi that seems to me to be significantly overstated at the beginning of the case.
Yes, sir.
You sought fees against Mr. Sethi that were the responsibility of the prior owner because that foreclosure against the prior owner, and you didn't pursue all of those fees. You asked for assessments that were the responsibility of the prior owner that would have merged into the final judgment of foreclosure, and you could have pursued him for those damages, but your client chose not to. So I want the authority that tells me What your client did at the inception of this case was correct.
Your Honor, I don't believe that we agreed that a merger occurs, but what I would say is we sought, or Chapel Pines sought, the amounts owed against the lot, not against the individuals
And you
themselves.
foreclosed against the lot, against the prior owner.
Chapel Pines did foreclose against the prior owner. Mr. Steffi took title November 15th,
And
2017.
so at the time he acquired title, he paid for that through the certificate of sale at the foreclosure. So what authority is there to demand from him monies that were the responsibility of the prior owner?
Under the declaration, I believe you have two different avenues of relief. Your personal obligation, both owners have their.
Counsel, I understand what an in rem and an in personam claim, what those two claims are. What is the authority under the declaration that the monies that could have been claimed against the prior owner somehow go to the purchaser at a foreclosure sale?
The monies under the declaration that are assessed against the lot is what the association shot. And again,
And that was foreclosed.
that was foreclosed up to a point, Your Honor.
So in other words, you're just saying, because we foreclosed a limited amount, we can still attribute to the next owner and pursue a foreclosure against the next owner, money that was owed by the prior owner.
Unpaid monies that were assessed against the lot, not necessarily the owner. Yes, Your Honor. I believe that's the position
So
we took.
the first foreclosure means what? You just get rid of that owner and you can, if you were able to foreclose Mr. Sethi, then any money he owed you would now say, whoever buys it, be aware you're going to pay for it.
Whoever buys the lot has a choice. And typically what happens in the foreclosure, Your Honor, is they will request a payoff indicating what's the amount owed on the lot itself. And we don't disagree that there was a demarcation line in the documents that say personal liability shall not pass to subsequent owners unless expressly assumed by them. But you're given a choice when you purchase from a foreclosure sale of the association. There are additional amounts that could potentially be accruing after your judgment is entered.
And so if there's a surplus at the foreclosure sale, your client's not obligated to go after the surplus. It can continue going after the property owned by the purchaser at the foreclosure sale.
I believe the surplus proceeds is pretty clear, only available to cover any junior lien holders. The association couldn't say, hey, I've got excess amounts. After the final judgment is awarded, these surplus proceeds should be applied to those additional
You can't
amounts.
go after the surplus, but you can maintain a lien on the property for those extra. How does that work?
The lien itself is based on each individual assessment. So every time a quarterly assessment in this case came due, the lot itself is lienable. And I think Judge Silverman, you pointed this out. Even in Mr. Sethi's case, we could lien for the amounts that were not foreclosed that he.
So you could choose, if you have an uncollectible owner who has filed bankruptcy, you could choose to limit the amount you claim in the foreclosure as to that owner, hoping that the successor purchaser is going to be collectible.
I think you limit it in the sense of your questioning to
Is
the
there
amount.
any
That,
case that supports what you're arguing?
I don't have one offhand, Your Honor. That was not the argument of the brief, and I
Why don't you-
apologize.
Why don't you move on? Because, well, I don't know, maybe my colleagues are persuaded, but I think I know where I stand on this issue, and I'm not convinced, absent some authority that you can point to, that the foreclosure doesn't eliminate the debt owed by the prior owner as to the lot, that the foreclosure leaves it open to whoever buys the lot down the road, and they're going to be on the hook.
Your Honor, I apologize if I'm not answering your question that you're putting forth, but I think
I
the issue,
understand your
There may not be an answer to it.
I don't have the answer off the
Well,
cuff.
I
for
understand the
this.
theory. I just don't see anything in the law that says you're right. And you haven't suggested that there is anything in the law or the declaration that says you're right on this theory, that the foreclosure does not wipe out the debt owed by the prior owner.
And I think, again, I may be, retreading the ground on this, but I think it's the difference between what is owed on the lot and what's owed individually. The lot's lien is each individual assessment, and each individual assessment that was unpaid, even after a foreclosure judgment, still liens the lot or is lienable by the lot if you take the appropriate statutory steps to lien it, which Chapel Pines did in this case. But focusing back on what we're here on today, that's not the issue that was presented to this court. As the court noted, a foreclosure occurred by the mortgage holder, which wiped out any in rem liability prior to that foreclosure date, except for the personal liability owed under the declaration for Mr. Sethi. And that's solely the issue the association proceeded under, which led to this February 24th, 2021 final judgment. It's what is the amount owed by Mr. Sethi? And if there are delinquent amounts, the declaration provides for interest, provides for attorney's fees and costs. How do we get to those amounts? To establish those amounts, the association submitted its renewed motion for summary judgment for only the assessments owed by Mr. Sethi from that half quarterly payment when he took title on November 15th, 2017, the January 2018 payment, and the April 2018 payment. Those payments were found by the court, no dispute, even admitted by Mr. Sethi.
Didn't the affidavit, though, have some entries for early 2017?
The affidavit had entries for 2017 because it was still the same amounts that were assessed. The assessment amounts did not change. And we were only moving forward on that delineated mark of the portion of the October 2017 assessment, January and April. That was the only amounts we claimed. I believe the trial court specifically asked counsel at that time, Ms. Io.
But the affidavit that your client submitted had additional amounts, correct?
It did, Your Honor, and it had a running ledger that associations keep, property ledgers that show the amounts that are assessed against the property. And there was no dispute that the assessments are what they are. And under a breach of obligation payment, all the association needed to show was, is the amount of assessment in dispute? The answer to that was no. Did you account for all of the payments? The answer to that was yes, we did. We had an affidavit of Mr. Haas on behalf of his client, Judge Sestek, instead of granting a receivership order, issued an order that counsel was to take payments from his client, keep them in trust until the conclusion of the case, to be applied to any amounts found delinquent. Judge Compton received the payments, canceled checks, the affidavit of Mr. Sethi accounting for all of the payments that Mr. Sethi had made. And there's no dispute that those payments were ordered by the trial court to be applied according to statute 720-3085 sub 3B. And that, I think, is where the problem is. Mr. Sethi, on behalf of his client, is arguing, I believe, that the court should consider any payments made after those 3 assessments to be current. And that's not how the statute is set up. That was the basis of the letter, I believe, that has been referred to, that counsel for the association indicated, look, there's a statute, the statutory payment hierarchy requires us to apply it in this manner, first to interest, late fees, attorney fees, costs, and then to the delinquent assessment. Any attempt to designate or authorize only the application of your payment in a different manner, it can't be done. And I believe there was sufficient argument in front of the trial court where the trial court decided, by including that specific fact in its judgment, that the amounts paid during the course of the case would be applied by statute upon determining the last 2 pieces needed, which was the attorney fees and costs to the association. And I know there was some talk about the July 2020 summary judgment, but again, I want to focus this court that we're not here on the lien foreclosure matter. We're here solely on what's owed personally for Mr. Sethi that led to the judgment on appeal, that February 2021 judgment, just indicating what his personal judgment is. On that judgment, I believe the court received sufficient, conclusive, undisputed summary judgment evidence to support its findings as to the principal amounts owed. Again, assessments owed by Mr. Sethi personally. The second issue appealed, the attorney's fees and costs. I believe my colleague touched briefly on that, but the court conducted a laborious 3 days of evidentiary hearings on this matter. We received testimony from an attorney from the association's counsel's office, received in the timesheets from the association's counsel office, went line by line on the last day of the evidentiary hearing to delineate which fees it would be awarding, which fees it would not be awarding, and the reason why. Transcripts of all 3 hearings are part of this record, cited by both parties in their briefs. The court received evidence from both an expert witness for the association, expert witness for Mr. Sethi, considered all that evidence and came up with the number of 76,000 and some change, reducing it pretty significantly from what was requested by the association. So there was no error
The
by,
association initially requested over 100,000, if I remember, and then it reduced it to 80-something thousand, and then the court reduced it further.
a significant amount based on the court's instructions, again, over 100,000. Yes, Judge Silverman, that portions of it related to the lien foreclosure case itself. And the court indicated in an order that there was no prevailing party on that count one lien foreclosure case. Only the association was prevailing party on the count two money damages claim. And that dovetails into our cross appeal issue.
Did the trial court make any findings as to the affirmative defenses raised by Mr. Sethi?
The trial court did not make any findings in its summary judgment order as to the affirmative defenses. That being said, the defenses, as Your Honor pointed out, I believe the first 3 or 4 related to equitable claims as to the lien. Those no longer applied with a money damages claim. Judge Lucas, I believe, pointed out the anticipatory breach is in reality just a payment defense. It is you're misapplying the payments. We deny that you are applying it correctly according to statute, which I believe that's just a legal issue on it. And the rest of it is some various form of payment. You've received these payments, you've rejected them, and that's simply not the case as reflected in the trial court's order. All the payment, the full amount are to be applied per statute. There's no dispute that I paid more or less than what the trial court found. And there's no dispute that the statute controls the application of the payment, notwithstanding a non-final order by Judge Sestek that instead of a receiver, counsel was to keep future payments in trust pending the conclusion of the case. And so moving to the cross appeal, if I have no further questions on the original judgment.
One other question as to the attorney's fees, the row factors that are in there. One of them has to do with the value of the claim versus the amount of fees and reasonableness. Was that argued to the trial court?
It was argued to the trial court as far as the experts opined on each of the row factors, including, Your Honor, the factor you mentioned. And certainly it is for the amount of the principal, a large fee award. But the fact that this case began in 2017 and was heavily litigated by both sides of the case to get to this point, each step of the way, I mean, you can see a 3-day evidentiary hearing on attorney's fees. Even that portion of the case was heavily litigated to get to the amount that's on appeal today. So this wasn't, I think, a situation where the trial court didn't take into view the entirety of the litigation, considered the row factors, considered what it had the opportunity to perceive throughout the case, and reduce accordingly. And I believe the amount the trial court found under the row factors should be affirmed by this court, with the exception that the cross appellant, Chapel Pines, filed 2 issues for this court that we believe requires a remand for those specific issues only. Number 1, that the trial court did not consider the work on the lien foreclosure count, a majority of those entries, to be inextricably intertwined. And the trial court made a specific finding in its order for the fees that found that the work on count 1 and count 2 were for the same common core facts, the same issue, money owed by Mr. Sethi to the association. That was the underlying facts that the association had to prove, both its lien foreclosure count and its money damages count. The entries which related to count 1, the trial court did not award, even though it made that finding that there was inextricably intertwined common core facts available for the association.
Doesn't that cut against you though? I mean, the fact that count 1 goes by the wayside because they just needed to go by the wayside. Wouldn't that just tend, like, you're putting a lot of emphasis, you're putting the bullseye on that, but it seems to me that Mr. Sethi is the prevailing party on that.
So I would disagree, Your Honor, to the fact that what was the issue that we were there on? The issue wasn't.
Well, the issue the homeowner association was there on was to get this relatively small amount of an assessment paid and its attorney's fees. And ultimately, hopefully from the homeowner association's view, it gets that secured by a piece of property because you're more likely to be able to collect that relatively large amount of money from a piece of property rather than a personal judgment against the individual. If you look at it from that point of view, you all came out way behind in this.
And I think that if in any aspect, when you have these types of small assessments and you have a heavily litigated case, that can certainly look like a lopsided balance. But
Well, no, listen, you see that in PIP, you see that in a lot of different cases. You see that in construction liens sometimes, you know, like a $2,000 construction lien, $100,000 of attorney's fees. I mean, that happens. I'm saying though, in terms of you didn't get a lien. You
We-
lost on that issue, which is where all of the security is for you all to get all those fees.
We did not have the ability to foreclose a lien. That is correct, Judge Lucas, and we did not have that
And
ability.
you brought that count.
We did, Your Honor. We did not have that ability solely based on not a
So having
defense.
lost that, why is it an abuse of discretion that the court found that there was no prevailing party as to count one, but a prevailing party as to count two? When the thrust of the whole action is count one.
Well, I think the pleading included two counts, Judge, and it was for both the lien and the money damages count. And again, it's just to recover money. That was what the payment was. And Mr. Sethi owed money to the association, and that's the remedy the association can
The
seek.
reason count one is count one, right?
Correct, Your Honor. Lien foreclosure is count one in almost all typical association foreclosure cases.
I meant that figuratively. It's the money one. It's the big one. You really don't want a personal judgment against these. I mean, you'll take it because that's all you were left with. But what you want is the lien on the real property that you can then foreclose and get all your fees.
Yes, Your Honor, with the security
Okay.
interest that you have, yes.
Okay.
But it wasn't a defense that led to the mooting of the count, and that's what the trial court found. It was a senior mortgage holder's foreclosure of the association's lien.
Which got bought out, just so happens by Mr. Sethi.
It did, Your Honor, and
Yeah.
that's I think where the argument Mr. Sethi made at the trial court level was, because I bought out the senior mortgage foreclosure, I shouldn't owe this amount. And that's simply not the case. There is still a personal amount that he owed at the time he took title to the case, even if we can't foreclose on those amounts because it's been wiped out by the senior mortgage. So the work, though, to get to that original summary judgment, which was awarded by the trial court on the lien foreclosure prior to being mooted, dealt with determining what the amounts are for the lien itself. It's work that had to be replicated at the same time we went for a money damages count. And so the association argued to the trial court, and the trial court disagreed, that it was inextricably intertwined. And that's the fees that we believe this court should remand to the trial court to determine what the reasonable amount is. If this court finds that it is inextricably intertwined work on both counts, you can't recover on a lien and a money damages at the same time. Recovery on one forecloses literally the recovery on the other. The second issue on cross appeal is it's a fees for fees argument, and that's simply a de novo review by this court of the language of the declaration. We've cited to the Waverly case out of the fourth trial practices out of this court. The Palma State Farm v. Palma's case has indicated general rule, no fees for litigating the amount of fees. That's the rule in Florida, with the exception of if a statute provides broad enough coverage, or if the contract, in this case, the declaration provides broad enough coverage. It's a reading of the declaration's provisions. The trial court determined in its order that it did not view the declaration's award or fee shifting provisions, as sufficiently broad to award fees for fees. Chapel Pines believes that the fee provisions, which, and I believe the quote is, and the cost of collection thereof, including without limitation, court costs and reasonable attorney's fees, legal assistance fees before trial, at trial, on appeal, shall be a charge and continuing lien on the lot and the personal obligation of the owner. And then further down, there shall be added the amount of the assessments, aforesaid interest, late charges, collection costs, attorneys and paralegal fees and collection costs shall be recoverable, whether or not suit be brought. So the cases that have viewed contract language, and it's been language that includes any or all. On the trial practices case, it was a consulting agreement, which included very broad language. We believe this is on par with that language that allows for an amount of fees for litigating the fee award on appeal with this court. And that's the second issue on cross appeal. We'd ask this court to remand to the trial court. Again, a number has not been determined. The trial court simply found that the contract language was not broad enough. We believe that was error. We'd ask this court to remand to the trial court with the specific instructions to determine what, if any, fees were reasonable for that litigation period. And if there's no questions from the court on either the judgment or the fee judgment or the cross appeal, I would tender the rest of my time.
you must have an internal clock that works really well because you just ran out of your time. So thank you.
Thank you, Your Honor.
Mr. Hull.
Thank you. Presiding Judge, could I try to answer a question that
Of course.
Your Honor, Honorable Lucas asked about a number of fees. And on page 48 of our brief, I actually tried to answer a similar question, which was the best and most competent and reliable evidence for the amount of time that the association spent by the time we tendered that payment back in June of 2018. The documents reveal an attorney fee total between $643.79 and $943.79 that could have been taxable to SETI if the association had simply answered the request. That's page 48, and we list the documents we cite to the record. We got those numbers looking at three documents: the demand letter of November 2017. If you look at the breakdown, then we look at the claim of lien, and then we look at the tail.
That's the position you're asserting, that, look, if they had just gotten back to me,
Correct.
that's the amount they would have
Correct.
spent.
So
I'm not.
it's not really
sure
answering
yeah.
your question about the evidentiary hearing.
I hear what you're saying.
Thank you, Your Honor.
Mr. House, I have one question as to the dropping or the mooting out of the foreclosure claim. Am I recalling correctly that you and opposing counsel agreed to the trial court that there was no prevailing party as to that count?
I wish we would have agreed, but here's what happened. On November 2020, when we had this fee experts there ready on Zoom to go, that's when the circuit court said, wait, you got to decide on, was there a winner as to count one? And the court basically, the trial court basically said, we're going to have a hearing. So the association did their motion asking for all those fees. I did a motion separately, which said we should get the fees as prevailing party, but I specifically put in there, but if not, there is discretion of the court to say no. So I cited to a case of McKenzie. And so I should say at the hearing in February 2021, they quickly conceded it was moot. And I'm like, well, it has been moot. And so why have you asked for fees beyond November 2020? That's why I was answering Judge Lucas's question. That's where it should stop, because we were right there with expert fees. And even the association has later said that, this is their words, it's difficult to understand what remained after July 2020. The February 2021 did not tread new ground. Well, they moved for judgment as to count one. They wanted to be prevailing party. That's when the court, when they acknowledged at the February 2021 hearing that it's moot. Of course, I'm not going to argue with that because at least they're not getting their fees, but I still made the argument by motion at the hearing as well that Your Honor should consider us the prevailing party. But if not, I think it was the McKenzie case that said the court could say, because it's moot, no prevailing party, which is what
You have
happens.
about a minute and a half left, so why don't you say whatever else you want to.
Sure. The color coded, there's no mention in their cross appeal of the color coded maneuver they made after the first evidentiary hearing. The first two of three were all their presentation of the case. Your Honor, I want to dispel the notion that Pudlett was an in rem case. That was the argument that the HO made, even in its briefs. And that's what the trial court believed, that it dealt with count one, not count two. In fact, Pudlett mentioned personal liability several times, personal obligation several times. Not once does it mention in rem. The Coral Lakes case of the second DCA is just like Pudlett. Your Honor, going back to the cross appeal, they did drop, and they should not get a second bite at the apple. I found a case of Booth v. Booth recently, which also talks about no second bite at the apple. They dropped it, and I cite all those references on page 22 in the record. They're not seeking anything that's not highlighted. Is there anything else the judge asked? No was the answer. We're not seeking. Your Honor, the 11,770 in the cross appeal closing argument is not evidence. When they refer to it in their briefs, they're referring to closing argument. And secondly, no documents, nothing was reviewed as to the 11,770. And there's no time entries that could be evaluated by the court or my expert. They're saying they want it now after they already told the court, no, we're not seeking.
And Mr. House, that brings us to the end of your time.
Thank you.
Thank you both for the presentation today.
Thank you.
And that concludes this case.
Thank you.
Our next case is Mercantonio versus Gertis. I hope I pronounced that somewhat correctly. Thanks, counsel. Okay, counsel.
Ready?
Yeah, I'm sorry.
Mr. Cavalier.
May it please the court. Good morning, your honors. I'm Dave Caldavia. I'm here today with Dan Clark, and we represent the appellant Joseph Marcantonio, who we refer to in this appeal as the plaintiff. I'd like to reserve 5 minutes, Judge Silberman. I have.
You got a lot of cooks in this kitchen.
Who's on first? What's on second?
I am correct that these two offers were made by Peak's counsel. Is that, well,
No.
straighten me out.
Okay.
Okay.
So the facts are very complicated in this case, Judge Rosa. To answer your question directly, there was an offer from Peak by a lawyer who represented only the driver. That's Mr. Brennan. That's one separate and distinct line of negotiations and agreement. And then there was a proposal for settlement in the law, filed in the lawsuit, served in the lawsuit by the Shelton McKean firm, who represented the driver and the parents. And the parents. And it was retained by Allstate. So maybe you're right.
But both offers were made on behalf of the same individual.
One was made by the driver, which was the PFS, and the other one was made on behalf of the driver by Peak, and required Peak to make a payment right in the words of the contract.
Well, does it really matter though if they're both being made on behalf of the driver? Because this, who's paying it or who might pay it, seems to me to be a non-issue as long as the offer is made on behalf of one particular party. Maybe they weren't authorized to make it, but they did. Presumably they were authorized because nobody's contending to the contrary.
Yeah, we don't know, but what we are
having a chain of emails that suggest that everybody was looking at what would be equitable stuff.
Okay, so that chain of emails was precipitated by a lawyer who represented only the plaintiff, the parents, okay? Only the parents. Never said, I am wiping clean and I have authority to control Peak's money. I'm a lawyer retained by Allstate to represent only the drivers, and I'm gonna broker a deal with you, Mr. Clark, that provides that Allstate's gonna pay 100 and Peak is gonna pay 100. Will you take that for a complete voluntary dismissal or complete settlement? Meanwhile, a different lawyer represented or hired by a different insurance company says, I got $100,000 and I will carve out, I'll get a partial release from your client to release the driver only for the $100,000 in coverage that he has with Peak. So it's a partial settlement from this guy. And then this other person says, I can broker a whole deal for 200,000. Never do they both say, we're all on the same page here and we're offering the same thing. As I said, the facts are very
I'll go back
complicated.
to what I asked though. Does
Okay.
that really matter if both offers are made on behalf of the same person?
Well, I
Well,
think,
you're suggesting.
I think
it
I can-
matters, and I'm trying to figure out legally why.
I think I can walk into a car lot and buy that car and that car. That's what was happening here. Driver was buying a partial release. And on this side, his parents and him,
No, the
We're-
driver, no, that's not how the offer reads. The offer is that the driver is offering to settle for 200 in exchange for dropping the whole suit, including his parents. But it wasn't made on behalf of the parents, correct?
are we talking about the PFS now? Or are we talking about
You tell me,
this second
you tell
one?
me which one,
Well, I'm
which
asking
is
you,
the offer that says parents want to offer X dollars in exchange for something.
so those discussions really were not very clear as to what the
that's not
term
what I'm
thing is.
asking, Mr.
Well, I'm trying to
That's
answer.
not what I'm asking you.
Okay.
I'm asking you, you said there was an offer by the driver here for 100, and there was an offer by the insurance company here for 200. But that offer of 200 was on behalf of the driver. It was in the driver's name, correct? I don't think we disagree.
It
on
was
that.
only the driver's parents' attorney who presented that offer.
Does that tell me why that matters if the offer is made on behalf of the driver?
I don't know that it was made on behalf of the driver,
That's
Judge.
how the proposal is worded though, isn't it?
How does a lawyer who doesn't
Now,
represent
Mr.
the driver?
Cavalier, is that how the proposal was worded? That's a yes or no question.
The emails say what they say, and
You're focusing on the lawyers involved.
yes, sir.
You're not focusing on the language of the proposal that was made on behalf of the driver.
And
Now,
that,
where that money was going to come from, it seems to me is irrelevant.
so that whole line of emails, by the way, regardless of who they were representing and who they were made on behalf of, that line of negotiations ended with a rejection from the driver's parents' lawyer from the Martinez Dembo firm saying, we reject. So at that point, we had left Mr. Brennan's original offer, $100,000 for partial release, and we had a proposal for
And
settlement.
I want to tag that first point a little bit.
Okay.
Because there seems to be this underlying assumption that you had this at all times, this $100,000 that got tendered, tried to get returned. Some kind of interesting stuff happens with checks going on with that. There seems to be this assumption and argument that $100,000 offer just kind of stayed open.
Correct. It did. In
Well,
fact,
see, and here's where I'm troubled by that. This court in Painted v. Fox held that when there is a disagreement about the scope of a release in connection with claim very similar to this, that acts as a rejection. So in other words, the scope of the release isn't just like a kind of minor detail that otherwise attends to a fully formed offer and acceptance. It is part and parcel of the agreement itself. So if you don't have that, if that original release is rejected, you have a rejected offer and it's gone.
so the original release was rejected. And then the second release was rejected. The third release was not rejected. That was the June 16th letter from Mr. Brennan saying, here's the carved out partial release that isolates your client's claim against the driver to the extent that it's covered by Peak, does not cover any claims that would be covered by Allstate, no claims covered by that the driver's parents are covered by. So yes, the first two offers were rejected. The June 16th is the one that was not rejected and still on the table.
Was it accepted?
Yes, it was accepted by Mr. Calkins' letter in September saying, here is the fully signed notarized release that you asked for and that you directed us. Remember, Judge Lucas, this money was in a trust account,
Right.
the $100,000.
They tried
We're
to
not
turn
allowed.
it, but they didn't.
Well, let's talk about that. A lawyer's not allowed to disperse money from his trust account without authorization from the person who that money belongs to. That we all agree that money belonged to Peak. We tried to send it back to them, or trial counsel did. I wasn't involved in the case back then. Trial counsel sent that money back to them, and they said, nope, here's your check back. Hold on to it. Let's try to work this out. Here's another release. No, we don't like that one. Okay, here's your check back. No, we don't want your check. Here it is back again. Try this release. Now, when we send that signed release back to Mr. Brennan, do they say, oh, no, that's not that deal off the table. You rejected that, or we don't like that anymore. We sent out PFS. No, they didn't send back the partial release that they bought for $100,000. They kept it. They still have it. That was not part of the proposal for settlement. The proposal for settlement, that's a contract. The release is a contract, right? It's governed by the law of contract. Proposal for settlement is a creature of statute and Rule 1.442.
It seems.
And that did not
Can
say
you-
anything.
Can you remind me what the September 2023 acceptance was? Because I'm a little fuzzy if that was just basically saying, okay, we're now in agreement about the release language, or we've got it. But wasn't it basically, if you're going to be formal about the creation of this separate contract, and to me, it seems like the argument really kind of hinges on that. Do we have a mirror image meeting of the minds about all terms, $100,000 release of the driver and only the driver as to Peak's insurance and whatever that gets you,
So, yes,
and release language finalized, all deal points,
yes. So if the letter is dated September 16th, 2001 for Mr. Calkin and Mr. Koulianos. It's on letterhead, and it's at a couple places in the record. It's at record 141 through 145, 168 through 173. And so you look at that letter and you look at the June 16th letter that Mr. Brennan sent. He says, here's the release that you asked for. It carves it out exactly the way you want it. As soon as you send that to me, signed and notarized, you can disperse the $100,000 that you have in your trust account. Those are the only instructions that we have about what we can do with that $100,000 that's in the trust account. The proposal for settlement doesn't say, and by the way, the rule at that time, Rule 1.442 in subsection C, I believe, said, if you have any special conditions or non-monetary conditions, whatever, but it says you have to state them with particularity in your proposal for settlement. Now, if Peak wanted us to use that $100,000 that was in the trust account, the lawyer's trust account, to apply to that proposal for settlement, the only way that could happen was with directions and authorization from Peak to use that money for that purpose. And that has never happened. Not to this day has it ever happened. So the proposal for settlement specifically says it's from the defendant, Mark Burgess, if I'm pronouncing his name right. If I'm not, I apologize. That's in paragraph 2. Paragraph 4 says the total amount of this proposal is $210,000. Paragraph 10 says there are no other relevant conditions or non-monetary terms. None. In the rule said, if there are, you better put them in that proposal for settlement. They didn't. They said there are none. That proposal for settlement does not state that the $210,000 includes the $100,000 that Peak previously offered to pay for the partial release. And to the contrary, it said that there's no other conditions. Everyone agrees that the PFS is a binding settlement agreement. Both sides moved to enforce it.
The sequence was, and I may have the dates incorrect, September 14th, the proposal for settlement for 210 was sent out. And
Was accepted.
Was accepted.
Well, wait a minute. I think you're right, Judge.
But bottom line
Yes,
is, it
you're
was a
right.
day or two later that your client sent to whichever attorney had sent the letter saying 100 plus the release. Is that correct? It was a day or two after the proposal for settlement.
According to my timeline, September 14th, well, September 13th, we sent out some proposals for settlement, which were our second step.
I don't want to.
So, but then the next day, the Shelton McKean firm sent out the defendant's proposal for settlement for 210, served it. On September 16th, we accepted Mr. Brennan's offer by letter.
That's what I thought.
Okay.
So it was
Yeah.
And then the
2 days later.
17th, we accepted the proposal for settlement. So yeah, it was pretty quick in time.
But you had the proposal for settlement on the 14th.
Yes, we did.
Okay.
And it did not revoke Mr. Brennan's and Peak's offer for the partial release that they had offered to buy for $100,000. So, you know, if we had accepted, what if we had accepted Peak's offer and rejected the proposal for settlement? According to the judge's reasoning, and we've gone to trial,
But the
we'd have a
Peaks
proposal for
Peaks
settlement.
offer was specifically only for Peaks. It did not release the parents, correct?
That's right, Judge. That's why we didn't, it's completely
And the
different terms.
second, and the proposal for settlement for 210 was in the name of the driver. And it asked that or as a condition that the lawsuit would be dismissed against the driver and the parents.
That's correct.
Okay. And you've got about, you 5.5 minutes, so I just wanted to let you know.
Sure.
We'll stay.
So, you know, the bottom line is that there's a separate settlement agreement whereby Peak purchased that release for $100,000. That agreement has been fully performed. Peak has kept the partial release that they purchased for $100,000, has not taken any steps to return that or rescind that deal. Regardless of though, if you say that, well, that there was counteroffers, that agreement was rejected, and that agreement's not enforceable against Peak. Irrespective of that's a dispute between Peak and the plaintiff, and there are remedies to Peak available if Peak thinks that it was that there's no enforceable agreement.
If you want to reserve your 5, you're at that point.
Okay, I'm wrapping up. Regardless of whether that agreement is enforceable or not, the proposal for settlement is enforceable, and it offered $210,000. And under the two main cases, I think two main cases should guide this court's decision, and that's the Universal Property versus Guerrillo Nero out of the 4th DCA, and the Suarez Trucking versus Saunders. Those cases stand for the position that the trial judge is not allowed to enforce a judicially revised proposal for settlement, and they're not allowed to look outside the 4 corners of the proposal for settlement and the acceptance. On those two decisions and the other arguments presented in our briefs, we request this court to reverse and to remand with instructions to enforce the driver's agreement to pay the $210,000. Thank you so much.
Good, thank you. You'll have 4 minutes for that.
Okay, thank you, Mitch.
Good morning, Your Honors. May it please the court. Sarah Sandler Cromer on behalf of the appellees, Mark Gerges, Ralph Gerges, and Ebtessim Hakim. Your Honors, there's really only one possible conclusion from the competent substantial evidence on the record before this court, and that is that the June 16, 2021 offer from Peak was rejected. And that's really the main focus of what this court's decision should be based on. It carries through to what monies were funded, what was owed to the plaintiff here, and what monies the plaintiff received. But for three reasons, we can tell you that you should affirm. First and foremost, the August 5th, 2021 correspondence from, I guess we're referring to plaintiff, co-counsel, we'll say, clearly rejects the Peaks June 16th offer. Additionally, the August 5th email that came in about an hour and 20 minutes later proposes a counter offer, a global counter offer to everyone. The timeline is admittedly a little unclear, but
This was the 300,000.
yes, I apologize,
Yeah.
correct.
Offers trying to keep track.
There's a lot. You're right. There's a lot of people involved, a lot of numbers involved. But we know that as of at least July 14th, 2021, there had been a global settlement offer for $200,000. That was offered by an attorney who was representing the parents here. She subsequently left the firm. We know that from the notice of change of attorneys. So we know that because it came from her, it had to have been sometime prior to July 14th. So we know that by July 14th, there had been a global settlement offer for $200,000. We know that on August 5th, 2021, an hour and 20 minutes after that rejection email comes in, is a counter offer global for $300,000. It's made very clear in the record that that was to all defendants as insured by both carriers. So in addition to the fact that we have this clear rejection, we also now have a counter offer which serves as a rejection as well. Even more so, if we were to get to the September 16th, 2021 correspondence, where there's an attempt to accept what we say is a failed attempt to accept a previously rejected offer, even if we were to consider that a new offer, let's say, there's clearly no objective assent to that. Even more so, we have ongoing negotiations. There's no meaning of the minds at this point as to what's going on. If we were even to ignore the proposals for settlement here and just focus on the line of that June 16th offer, here's what we'd see. We have the June 16th offer. Nobody responds to that for a couple of months. Finally, co-counsel for the appellant comes in and he says, hey, I've entered an appearance here, include me in on these things, to which the attorney for Peak responds and says, well, we've got, here's the lay of the land. We've had these two offers that were out there. We've since put this third offer out there. Here it is. I've attached a copy. That's the deal. He actually doesn't even ask for a status of it. He kind of just lays it out there. To which counsel responds, I apologize, co-counsel for the plaintiff here, to which he responds, well, that tender and release, those were rejected. From that point forward, if we're still following the trail of June 16th, from that point forward, all correspondence is with regard to global settlement offers and negotiations. Several emails come in from co-counsel for the plaintiff, which make it very clear that these counteroffers, this global counter offer for 300 is for all parties to completely settle the suit. He even says, I want to get this thing wrapped up so that we don't have to spend any more time on litigation. So we know that this global counter offer applies to all the defendants and applies to all carriers. Even more so, it references and acknowledges that initial counter offer global settlement offer for 200 was for the limits for both carriers. Of course, they're already in possession of the Peak policy limits for 100. So even if we were to follow that June 16th offer by August 5th, it's off the table, whether that's because there's a clear rejection of it or that's because there have been counter offers involved. From that point forward, the next correspondence we see, there's actually even additional medical records exchanged. There's an update on the medical bills. We know that defense counsel has engaged in their own conversations. But we've all moved on from this June 16th offer. We're now considering whether to take the $300,000 counter offer. From that point forward, the next thing we hear is on September 13th, where counsel on behalf of all defendants says, we're rejecting your $300,000 global settlement offer. that afternoon, we see the PFS. The next morning, we see the opposing PFS. And then, of course, there's this acceptance letter that comes in 2 days after the PFS is served. There could only be one conclusion about that September 16th letter, and that's simply that it was a failed attempt to accept a previously rejected offer.
Remind me of one date. I just can't find it right now. When was the final release, the one that was ultimately signed and sent back to the attorneys on the defense? When was that one offered to the plaintiff's counsel?
That release was sent, so that would be the third revised release that was sent on June 16th.
So it was before I think it was Mr. Clark's email that said the offer and release had been rejected.
Correct. Yes, Your Honor. And then we see that plaintiff's counsel tries to accept that on September 16th. Even if we were to consider that a new offer, there's no objective and clear assent to that offer. This idea that Peak holds on to the executed release, frankly, is a non-issue. It's essentially silence from Peak, which cannot serve as a clear objective acceptance of that new offer. Even more so, we know that within less than a month of that executed release coming in, the litigation over enforcement of settlement begins. So Peak's position is very clear in less than a month that they're not considering that an acceptance of the offer. So really there's by the September 14th proposal for settlement, the only offer on the table for the plaintiff to accept was that proposal for settlement. It was in the amount of $210,000. I believe that Allstate's check was cashed September 28th. So by September 28th, the plaintiff is in possession of the $100,000 tender from Peak, the $110,000 from Allstate. Proposal for settlement has been properly funded, and now we're here. But I think the real issue for the court is to consider that June 16th offer and where did it go and what happened to it. And at the end of the day, the trial court found that it was rejected. And at most, the September 16th correspondence was a new offer that was not accepted. And I think the substantial evidence before this court absolutely confirms that. And certainly we request that you affirm. I'm not sure if the court has any additional questions. I'd be more than happy to answer.
Very good. Thank you, counsel.
Thank
Mr.
you.
Padilla, your 4 minutes rebuttal.
May it please the court. So I'd like to quickly respond to Judge Silverman's question about the timing. Yes, the third release and the offer that we contend was on the table was the September 16th letter from Mr. Brennan to Mr. Koulianos and Mr. Calkin, I believe, with the release enclosed. And then Your Honor said, and after that, Mr. Clark's email rejected that offer. That is where we disagree.
No, it doesn't say rejected. It just says that was rejected because of the release that was mandated,
So
as I recall.
So that's what he says. And that email cannot be the rejection if it's referring to something in the past tense that already happened. And what it's referring to is the rejections that's described in the communications exchange or the correspondence exchange, which are the letters rejecting the first two releases.
What about the other part of your friend's argument that, but by making a global settlement, that is in a new global settlement offer, 300K
So-
covers everything. That is in itself a counter offer that acts as a rejection.
So it was a counter offer to the Martinez Denbo's firm's settlement offer for a $200,000 broker deal that they said they could do. They came in and made an offer to him while Mr. Brennan's offer was pending, and he made a counter offer. He never said, I'm rejecting that. He never communicated his counter offers to Mr. Brennan or Peak. He communicated to the person who made that offer. And so there was two transactions going, there's two sets of negotiations going on at the same time. And counsel says, well, the fact that that Peak never returned the release, that's a non-issue. Really? Well, why not? They kept that release. They still have it. When they didn't want us to return the $100,000, give them back the $100,000, they sent the checks back. They kept the release. They still had the release. Why? Because they bought it. They bought it for $100,000. And if they want to get out of that deal, they have remedies. That's separate and apart from the PFS. And Suarez Trucking is dead on. It says what has to be done here. You go by the four corners of the PFS and the acceptance of that PFS, it requires $210,000. If Peak doesn't want to doesn't feel like they paid, that their money was used the way they authorized us to use it, that money from the trust account, that they authorized us to pay it from PFS sub silentio. If they don't like the way that went down, they need to file a complaint for rescission or unjust enrichment, or to undo that contract somehow that they made. We're dealing with very sophisticated parties, 3 sets of attorneys. I know my time is up, but this is not as easy as it seems.
Seconds left. I don't want to rush you.
But this is a tough case, and the facts are murky. But I think the Suarez Trucking case tells you everything you need to know, and that is that this proposal for settlement needs to be enforced for $210,000. If Peak doesn't like the way its deal turned out, then it has remedies, and we're ready to address those remedies. But the PFS stands on its own. Thank you, Your Honor.
Very good. Thank you both very much. Appreciate that. The next case is, forgive me again, Paglialonga versus Crescent Beach Club Fan Key. And we will, for those who are here for the 4th case, Gallon Care, we will take a break after this case and then handle the Gallon Care case after that. Come on up whenever you're ready.
May it please the court. My name is Robert Anthony. I represent the appellants, and you got it right, Judge Silverman, is Paglialonga. That's one of the 5 condominium owners.
I think you're being generous with how I pronounced it, but thank you.
I think you did pretty well. I would like to reserve 5 minutes for rebuttal. Thank you. So I represent the 5 condominium owners. This is a case between the condominium owners and Crescent Beach Club, which is a condominium association. The first issue on appeal, it's a very narrow issue. It's if a party who sues you announces that they no longer believe that there's a dispute, does the initial dispute just go away? Because this is a case that Crescent Beach Club sued the 5 condominium owners. They sued us in arbitration under 718.1255. That's the condominium statute. That was the initial dispute between the parties. Crescent Beach Club sued the 5 condominium owners. That initial dispute had 2 main parts. First, the association contended that these 5 owners were violating a 14-day minimum term provision in the declaration. Second, they said they were advertising and informing others that they could rent the unit for less than 14 days, and that the advertising confirmed this illegal renting. So under the Department of Business and Professional Regulation, when you file this mandatory non-binding arbitration petition, and they filed 5 separate petitions against these 5 condominium owners, you can be ordered to go to mediation at the DBPR level. That happened. All right, there was an impasse at mediation. So of course, impasse, there was no resolution at that mediation level. So what happens next? under 718.1255, what happens next is that the arbitration case is dismissed. And then you have to get to the statute of this narrow first issue. The arbitration case is dismissed. What rights do these condominium owners have to have a determination on the merits of those 5 cases? What?
Am I correct, Mr. Anthony?
Yes,
The trial court is being asked to opine on what would have happened had the case proceeded to arbitration.
the trial, the way that you phrased it, I think is accurate, because the trial court is being asked to conduct a trial de novo, which would be what would have happened for those 5 cases before the DBPR.
Why is that not asking for advisory opinions when the parties appear to have resolved these issues?
Right, when the appeared to is critical, right? This was on a motion for summary judgment. The evidence was that there was no resolution. Now, the association contends there was a resolution, that there was no present dispute. So the issue is, can that initial dispute be resolved? And the critical part about it is not asking for an advisory opinion, because the statute says that upon dismissal, either party has the right to have the case heard in a court of competent jurisdiction and to seek the attorney's fees that they incurred at the arbitration and at the mediation. Both of those things, the statute specifically says that you're allowed to pursue.
But there still needs to be, now that we're in before trial court, there still needs to be an active dispute between the litigants.
Well, the active dispute is the arbitration petition that accused the 5 owners of violating the 14-day minimum term provision and by advertising that people could stay for less than 14 days.
To my mind, what you've just done is you've just dovetailed the statute's language that says either party may institute a suit in a court of competent jurisdiction. You just dovetail that into your separate issue on appeal, which is that the statute gives you an independent cause of action. Because there is no standalone cause of action in Florida law that says you can have a trial court determine what an arbitrator would have done had an arbitration that had been dismissed gone forward. There's no such a standalone cause of action, right?
There's no standalone cause of action under 718-1255. It's the procedure of the condition precedent to go to court. The cause of action was breach of contract. CBC sued the 5 owners for breach of contract, breach of the declaration. That's the cause of action. But we were the defendants in the arbitration case.
After the mediation reaches impasse, the arbitration is dismissed, but the parties continue to resolve the underlying issues as to the nature of the advertising and the term of the lease. By the time they get to the trial court, I'll use the word again, but whatever underlying the arbitration or the mediation has now been resolved. So here's my active case or controversy.
It has not been resolved in the eyes of the 5 condominium owners, all right, because there's never been a settlement agreement. There's never been a payment of the attorney's fees that were incurred at the arbitration level, which the statute specifically says you're entitled to seek in the subsequent litigation.
In a suit, you have to file a suit. Your suit here was a deck action, correct?
It's a declaratory judgment action because we couldn't sue them for breach of contract. You know, the breach of contract was what they sued us for.
So you're for better or for worse, you're stuck in the law of deck actions. And the law of deck actions is you have to have a live controversy.
Right.
And
And
it can't just be an advisory opinion,
that's true.
which is what
And-
Judge Rose was touching on.
Right. And we're not saying that this was seeking an advisory opinion. We're saying we're seeking the opinion of, did we violate 14-day minimum term provision for allowing people to stay less than 14 days and by advertising that people could stay for less than 14 days, as long as they signed a 14-day minimum term lease.
But if the association has conceded that we've seen the light, that is not a violation of the declaration, then how do you cabin for a moment, just put it aside, trying to recover your attorney's fees, put that aside for just a moment. What legal rights get vindicated? What other relief do you get? How does your client get any better off when the association has said, yeah, that advertising is okay, we're now singing from the same hymnal on that?
Well, the way that they say it in their answer.
It's that use of the present tense. I get it. I get it.
Right. The way that they say it is, okay, we don't have a present problem with what you're doing.
But you may in the future.
And not only may in the future, they don't provide any specificity about what is it that they don't have a problem with, because the declaration doesn't allow them to even have any say about advertising. All right, and it's important that the 5 condominium owners can advertise however they want to advertise, because there's no restrictions on advertising, and the association is bound by the declaration. They are allowed to require a 14-day minimum term lease. So the critical issue here relates to trial de novo and the statute that says this mandatory non-binding arbitration procedure is not intended to eliminate or the statute says is not intended to avoid your right to a trial de novo. This is critical because 718-1255 was a legislative attempt at alternative dispute resolution because associations are more powerful than the owners generally. That's what they say.
Don't we have to assume that when you're seeking a trial de novo, you are dissatisfied with the result announced by the arbitrator? And we have no result by an arbitrator.
Right, you're dealing with subsection K.
Yeah.
We're dealing with subsection H. And subsection H says if there's a mediation impasse, this is what you have to do on subsection 8. It says, if the parties don't agree, then you get dismissed, and either party may institute a suit in a court of competent jurisdiction. Either party. Now, the beginning of the section says nothing in this provision shall be construed to foreclose the parties from proceeding in a trial de novo. All right, and
Suppose you ask for a trial de novo and you move forward and the parties resolve the case. That's the end of the story, right?
if they resolve the case in the circuit court case.
Okay.
But they didn't, there was no settlement agreement, there's claim for, and again, it's claim for attorney's fees back at the arbitration level and at the circuit court level. But if you read these statutes, the statute's supposed to preserve your right to be heard, its case to be heard. Its case was the case they sued us over. Its case is that case in the arbitration, those 5 different cases. That's the case. It's not an advice.
As an old saying, the plaintiff is the master of the complaint. If the plaintiff doesn't want to go forward with the plaintiff's case, you as the defendant can't make them. So I think your appeal, your case here has to rise or fall in the deck action.
Well,
You keep trying to bring it back to the breach of contract action, but they were the plaintiff there.
Yeah, but the statute says either party.
If the statute says you may institute a suit in a court of competent jurisdiction, that party was that you just set up here. You're not seeking a breach of contract action, right?
We're seeking a determination that the breach of contract action was wrong on the merits. That's what we're seeking. We're seeking a determination that those 5 condominium arbitration cases, that the breach of contract and the request for injunctive relief, they were requesting that we not inform others.
I think your better argument is, instead of keep trying to tie it back to the cause of action that they brought, which has gone by the wayside, to me, it makes more sense for you to argue along the lines of, we need a declaration that our advertising practice and our rental practice at that time was okay under the declaration. Because we're still in doubt about our rights based upon the way that they've answered this soccer complaint. We would like to go back to advertising the way we used to and renting the way we used to, but we're not sure that they're not going to just sue us again. To me, that's a more cogent argument about what a deck action would be.
Right, but that's what the amended complaint says. The amended.
Right, but you keep arguing that it's a breach of contract.
No, but the amended complaint says, all right, that our leasing practices should not be restricted. All right, and the evidence is that our leasing practices never changed, that not before or not after, the arbitration case, that our leasing practices, which includes the advertising, that you can stay for less than 14 days. Now, to me, the critical issue is this statutory framework. That's the start of the litigation process, this statutory framework, and it provides nothing is to prevent you from having a trial de novo. So that's where we get, and I know I only have 2 minutes left. I want to get to the notice of supplemental authority, which is the Allison versus Carrollwood case that just was decided 2 weeks ago, and Judge Silverman wrote the deciding opinion there. In the Allison case that was decided, it was a trial de novo after an arbitration decision, right? After an arbitration decision, and it's non-binding, right? So you're able to go and have the matter resolved in a court. It's the same thing, the respondent at the arbitration level, they had to go sue, declaratory judgment. There was no issue. That was the way you do it, because you were the one being sued. You're not bringing the cause of action. You're defending the cause of action.
The distinction with Allison, though, is that there was a trial de novo of issues that were decided in the arbitration. So they were still susceptible of being reviewed and considered in the trial de novo, correct?
That's true, that because they had an actual arbitrator's decision, but it was non-binding, right? So the same principle should apply, that the trial de novo is required under the statutory framework. The trial de novo is required. It's not discretionary. You're entitled to a trial de novo of the issues that were brought in those 5 arbitration cases. In Allison, the court defined what's a trial de novo. The trial de novo is a trial of the entire case in the circuit court. The entire case that was in the arbitration
It was
case.
a deck action. Allison was a deck action.
It was a deck action, and so is ours. We want a trial of the entire case that was in the arbitration cases, just like they did. They wanted a trial of the entire case in the circuit court from what was the non-binding arbitrator's decisions in the arbitration case. And the definition of the trial de novo that you put in your opinion was the trial de novo determines liability. Okay, it determines liability. And what's the liability? The liability is from what was asserted in the arbitration case. I know I have less than 5 minutes. I'd like to reserve for rebuttal. Thank you.
Thank you.
Thank you, Mayor. Please the court. I'm Brian Hull on behalf of the Appalachia Crescent Beach Club at Sand Key Condominium Association, Inc. And this appeal really comes down to 2 simple questions. Number 1 is, did the trial court properly decline to issue a declaratory judgment to decide a past dispute over who would have prevailed in the arbitration? And number 2, did the trial court correctly decide that section 718.1255 does not create a new independent cause of action? And on both of those issues, the trial court's summary judgment order got it exactly right. In this case, what the unit owners asked the court to do it was issue a declaratory judgment that decided the request for relief that had been made in the prior arbitration petitions. And those petitions addressed past leasing practices under former leasing documents. And those practices and leasing documents all changed at the time that arbitration was dismissed. This suit came 8 months later. This is not a situation, not a case where the owners claim to have lost out on any rental income or suffered any damages because of past instances where the association refused to approve their leases, for example. This is a case where the owner simply sought a declaratory judgment about whether their past leasing under former leasing documents would have been in violation of the declaration.
Mr. Hall, let me ask you a question. In terms of the mediation, which was at an impasse, had your client at that point in time said, you know what, we're wrong, we're not reading it the right way, we're going to change it, so you're all okay, would they be without remedy to the extent they incurred fees and costs in the arbitration and mediation?
If that had been the scenario, is your question? If our client midstream in the middle of the arbitration.
No, after the impasse.
Okay.
Your client, excuse me, after the impasse, if your client says, you know what, we get it now, we think we blew it, you don't need to file a trial de novo, we're not going to enforce it in this way anymore, would they be without a remedy?
And in your scenario, setting aside any changes that any parties
Right.
made, same set of facts,
No,
had the facts been.
your client just says, we're wrong,
Yes.
we now see it.
Sure. And in that scenario, I would say that they are not entitled to fees under the statute. Examining the language of the language of section 718.1255 in a scenario where the arbitration is dismissed as a result of an impasse at mediation, the remedy is for the owner to file the suit, pursue the litigation, and then at that point, at the conclusion of that litigation, they're entitled to seek their fees for both the litigation and for the arbitration and mediation. And in your scenario, I think it would be a situation where they wouldn't be able to pursue that claim because yet again, there would not be a present dispute. So the legislature didn't set this up in a way that they would be entitled to fees. The language of the statute only overrides the American rule to allow a fee award where the arbitrator renders a decision on the merits and that the fee award goes to the party who prevailed in the arbitration, or in the situation where there's a trial de novo, which again, trial de novo, as you've observed, comes up only after there's been an arbitration award. And under the statute, fees can be awarded there.
Under the statute, if it's dismissed, any party can see. You don't necessarily have to have an award. You could have a dismissal of the arbitration under the statute and have a trial de novo. You still got to fix. I think your point though, that it still has to be under a recognized cause of action. I get that, but there can be a dismissal of the arbitration. You can still seek a trial de novo. Either party could, right? Under the text of the statute.
Under subsection 4L, I believe a trial de novo comes after there has been an award, and so they're asking for a trial de novo to basically re-examine the issues that were decided in the arbitration.
I think it's might have been H is what I was looking at there.
Subsection H is the one where there's an impasse at mediation.
Right, and then which then contemplates that, and then says, hold on.
Yes, no, I think I understand your point. Yes, under subsection H, could a party sue if, say, the case was dismissed, the arbitration was dismissed without an impasse at mediation? The way subsection H is worded, it allows either party to institute a suit in a court of competent jurisdiction. That clause follows the phrase, the arbitrator shall enter an order of dismissal. Would they be able to pursue an action in court if the dismissal came not as a result of an impasse at mediation? I don't know that they could under subsection H. I don't think the legislature had contemplated that specific situation where the case was just outright dismissed without an impasse at mediation.
But you would still have to satisfy the constitutional requirement of a live controversy.
Absolutely. At any point in time, if you want to bring that case in court, you have to have a live controversy, no matter where the parties stay.
Let me follow up on my question just a little bit differently. If after the impasse, and I know this is a hypothetical, so work with me on this. If after the impasse, your client says, we misread it, we're not going to do anything. And the other side says, well, wait a second, you took us to an arbitration that was frivolous. We think you had no basis for it, and you've now conceded that you read it wrong. Under the declaration and the articles and the restrictions, the covenants and so forth, would they potentially have some sort of breach of contract action? And if the answer is maybe yes, maybe no, we don't know in this case, but let's assume the answer is yes, they might. They'd still have to go back to arbitration at that point on this new claim.
If there's a new claim and it fits within the meaning of a dispute under section 718-1255, then yes, that would have to go back through arbitration. I don't know if under that scenario, that particular issue would meet the standard of a dispute within the meaning of the statute.
Well, or a dispute within the meaning of the restrictions as well, the governing document.
Sure.
Okay.
Sure, but in this case, we're dealing with just two causes of action, the declaratory judgment action and then the suit on 1255. And based on just the allegations that were in front of the court here.
And there was evidence, if I recall correctly, there was information presented to the trial court that the parties together figured out a solution that would work for them.
Yes, Your Honor. They did work together. The association had presented the unit owners with some changes that they were proposing to their, I believe, rules and regulations, as well as their leasing materials. And in the association's view, all of that worked together to resolve their concerns, to resolve their issues with the unit owners' leasing practices. It required them to identify, are these people going to be staying during the entire term of their lease, or are they going to be doing these shortened occupancies? When are they going to be on the property? When are they coming? When are they leaving? Those sorts of things to address the association's concerns about security and other issues like that. So yes, the parties did work together to an extent, but ultimately the association came up with new leasing documents that addressed all of those issues. And so then the question becomes, under these new leasing documents, is there any sort of violation? And the association has always taken the position that there is violation now that they've developed these new documents, now that they have implemented these new rules and regulations that make very clear to the new tenants that they have the ability to stay the entire 14 days, even if they had made arrangements with the unit owners that they were only going to stay a shorter time. The declaration itself gives them the right to stay there for the full term. And now the tenants know that.
Putting aside the advertising issue, was there any dispute that the homeowners were in fact renting units more than 26 times a year?
I think that was still an open issue. That was still an open question. I believe that on summary judgment, I think that all that you had in the form of deposition testimony was just an expressed uncertainty. I don't think we came up with, in opposition to their summary judgment, specific instances of where that occurred.
Okay, so this is kind of goes to that, the way that the framing of there is not presently a controversy. Would you agree or disagree that if there was a dispute about whether or not any units had been rented more than 26 times a year, or there was an overlap in rental periods, that would be a subject right for declaratory judgment?
If there were facts where we thought that they were indeed.
In fact, it's an allegation in the deck actions. Paragraph 29, plaintiff units are not now and have never been rented more than 26 times per year. No leases rental term for a given unit overlaps with the term of another lease for the same unit. Homeowner association denied that allegation. Why isn't that still right for determination as a deck action? Because if that happened, put it this way, the way things stand right now, there's no reason why the homeowner association could not come back and say, hey, we've now found some information, and we think that you were in violation of this provision, and we want to go forward with that in arbitration again.
I think our position would be, if they were indeed leasing more than 26 times a year, then that would be something that we would be litigating. Yes.
Yeah. So why is that? You're not really telling me anything about the state of the case, though, deck action, because the deck action put that issue before the court. And that issue you just confirmed really isn't resolved.
They haven't asked for permission to do that. Okay, their deck action says.
Try my question. My question was: is there controversy about whether or not that has happened? And you're not telling me that there isn't a controversy about it. And that issue was put before the court of the deck action.
I think that their issue, they have consistently said that they are not doing that. And we said in response, we don't know if they're doing that or not.
You denied the allegation. So that's a controversy. And it directly, I mean, it's point blank right on a restriction in the decks. So
But
why don't we have a deck action on that? Have the court figure it out.
well, that's not a present controversy because we're dealing with the new leasing documents, and are they in violation of the new leasing documents with their current leasing practices? We're not talking about the old leasing practices. We're not talking about the old leasing documents. What we're talking about is on the facts alleged in the complaint, are they in violation of the declaration? And we have never taken the position that these new practices are in violation of the declaration.
So what you're saying is what's happened has happened, that's in the past, and the association would not seek to litigate those past issues about if in fact the units were rented more than 26 times. That's water under the bridge. You all would not bring that up again in a subsequent.
There's no need to litigate that issue.
So yes.
Now, if it comes out, if the association learns
Is that a
in the
yes or no?
we have no need to litigate that issue.
That just tells me that there is a need for declarations, Joel.
And maybe I'm missing your point. I don't
My
know.
point is
I don't
that
see
there
what.
was an issue brought before the circuit court and a deck action that we have not and have never and are not now. We've never done it in the past, rented these units more than 26 times per year or had an overlap.
Mhm.
And you're not willing to say today whether or not that there's no controversy about that. And if that's a controversy, then the court had jurisdiction to decide it.
We are not challenging whether or not they were. I don't think that's an issue whether or not they were in there for 14 days or not. They say they weren't. We said that's
You
not
denied it.
that's not a problem.
You didn't, but you denied it in your answer. At least I should say the homeowner association denied it in their answer.
Because we didn't have the information whether or not they were indeed signing leases that put people in there more than 26 times per year.
And as you stand here today, on behalf of your client, you can't tell me whether or not that past issue is resolved or not. All you've said is basically we don't anticipate bringing arbitration at this time, which does nothing to assuage the concerns that the homeowner association might have, which is that we find ourselves in arbitration again about these past practices.
Well, they have not asked to lease for more than 26 times per year. They're not asking to do that.
Right?
If they were asking to do that, then that would be a situation. Or if they were violating the term that if they were putting people in there more than 26 times per year, then yes, that would be an issue. But the way they've alleged it is that there are not people in there more than 26 times a year. They've never done that. And if that's indeed what they did, we don't have a problem with that. And we have created these new documents that now allow us to address our concerns, which was the fact that they were putting the people in there for shorter occupancy.
So if that happened in the past, that would be water under the bridge, because now you've got the new documents in place.
Right.
Okay.
Now we have the new documents in place. With respect to the statute and whether or not it creates a separate cause of action, I think the legislature used very clear, unmistakable language that it's a condition precedent to suit, did not create a brand new cause of action. And that's what the trial court correctly decided. As far as a trial de novo, that issue just does not apply without that arbitration award, without the arbitration decision. I would say that the type of suit that has been filed here is not what the legislature had in mind when it enacted Chapter 718.1255. The unit owners were not entitled to a declaratory judgment to decide a past dispute or decide who would have won at the arbitration. And even if a declaratory judgment had been appropriate, Section 718.1255 still would not allow for an award of attorney's fees in that situation. The trial court correctly decided that this case does not involve a present dispute worthy of a declaratory judgment, and that Section 718.1255 did not create a brand new cause of action. The final summary judgment should be affirmed.
Very good, thank you.
May it please the court. Um, the question, Judge Silverman, that you asked is a good question as far as, are we without a remedy? And this is a legislative statute for alternative dispute resolution. Is not to deny you access to the courts. You're supposed to have a remedy. Otherwise, it's an alternative dispute, like we said in our brief, alternative dispute non-resolution, right? We should have a remedy in court when we are sued by the association and they seek attorney's fees in those 5 arbitration cases under 718.303. They seek attorney's fees under the condominium statute, and then they just walk away. It is analogous to a voluntary dismissal. And with everything else the same, if they had done that in court, then the 5 condominium owners would have been entitled to their attorney's fees. So this statute, though, says that you're entitled to seek your fees in the subsequent litigation. So the trial de novo introductory language in 718.1255.4, the introductory language says nothing in this provision is to foreclose you from having a trial de novo. Now, in subsection H, it doesn't use the phrase trial de novo. Agreed, it doesn't. Subsection K uses the phrase trial de novo. Subsection H uses the phrase subsequent litigation. But that introductory clause, it means something. It means nothing in this provision should prevent you from having a trial de novo. And the association, Judge Lucas, the association, they denied almost everything that we alleged in the First Amendment complaint. They also denied, that we were not in violation during the time of the 5 arbitrations. They denied that too. And they denied virtually everything. They didn't admit much of anything. So at his deposition, when pressed, hasn't this been resolved? Mr. Paglialonga said, not at all. This is on pages 2377 through 2379 in the record. Not at all. There was no resolution. It was never resolved. And then later in his testimony, 2374 and then 2391, he says our leasing practices didn't change. And this is critical because the old leasing documents, the very first page of the old leasing documents, it says minimum lease term 2 weeks. It says it right on the leases. We've never had leases denied before the arbitrations, after the arbitrations. The leases have always been approved. There's never been a denial. So now they're continuing to approve them, but they have no right. They didn't have a right then. They don't have a right now. They don't have a right to challenge our advertising. People can stay for 3 days, 5 days, 7 days. And that's what the Green versus Grider case confirmed. This is the second DCA case. And the reasonable inference, of course, this does summary judgment. The reasonable inference is at mediation, when we brought up the Green versus Grider case, they realized, uh-oh, we're wrong. They can tell people they can stay for less. But then they say that we admitted or that we cooperated with them. But we cooperated with them because they have the absolute right to put in the leasing package when people come, when people go. What they don't have the right to do is challenge our advertising. We can advertise. And if you want to look at the evidence that they cite for cooperation is emails from 3 of these condominium owners. And it's in the record at 2266 through 2270. Those 5 emails are chastising the association for having brought this case in the first place. Right? One of those emails from Mrs. Paglialonga says we've never rented the unit more than 16 times last year. Not 26 would be our cap. We rented it maybe 20 or 16 times last year. Mr. LeMajeur and Ms. Stockton saying we've been falsely accused. Clearly there's been no violations. Okay, but we've still not had a determination that there's been no violations. All right, we deserve that determination. They can stipulate to it in the circuit court case that there was no violations and there are no violations. And then we get our award of attorney's fees. And that's the critical issue, really, is the statutory framework And in our brief, we talk about access to the courts. A statutory framework of alternative dispute resolution is not supposed to deny you access to the court. If somebody sues you, you should have the right to go to court and have it resolved. What's happened here, the trial court on summary judgment, despite evidence that there had been no resolution, the trial court says, I don't have to determine. All right, because I'm going to find that there was a resolution.
Anthony, we are at the end of your rebuttal. So thank you both very
Thank
much.
you very much.
We will take a 10-minute recess and then we will come back for the last case on the docket.
All rise. Stand in recess for 10 minutes. Thank you.
All right.
Okay, you too.
Thank you.
Yeah, nice to meet you too. Only seen you on Zoom.
I guess, yeah. Always kind of strange coming back, doing these live.
Yeah. I noticed they have one tomorrow on Zoom. I wonder if they could have flipped it so we didn't, we didn't have to work on Labor Day, but I like I'm glad we're coming back live.
Yeah. I was talking to some people, I like the Zoom, but
It's good for something.
yeah. I have to say, this is the first time I've been on oral argument about a petition.
Oh, really?
Yeah,
I've had a lot.
I was actually surprised.
Oh, yeah.
I mean, I would think that there'd be more, but just almost never
Yeah.
this weekend.
We have to ask for it.
Yeah,
So I don't think you all asked. I think.
no, it was you. And I normally don't on petitions.
Yeah, I pretty much always ask for oral argument if I represent the petitioner or the appellant. It's pretty rare I wouldn't. What's that? I thought you were gonna let us know they can hear everything we're saying.
Yeah, they probably can.
Um, but when I'm in the happily or respondent, I don't always, that's for all argument. So, anyway.
Yeah.
There is a petition for a non-final appeals in the appellate court. I'm seeing that they seem to be granting, not so much this court, but in general, the DCAs are granting fewer oral arguments, I think.
Yeah, I'm getting a lot of them that are being, they're scheduled and then maybe 2 weeks later, they're dispensed with. Fifth is doing that a lot.
Yeah.
I think the sixth is just trying to catch up from everything that was kind of dumped on them.
Yeah, I haven't had an oral argument there yet. I haven't even had any cases. I have some cases there, but none that have been decided.
I have 4 right now, and 1 was decided, and I'm still waiting on 3 opinions.
I've found them to be very slow in motion practice.
Yeah,
I think they're still getting their legs going.
yeah, that's, I was gonna say the same thing. They're still trying to get their legs and get the process, yeah. Kind of like when you go to a restaurant the first time, so yeah, give them a little time to get everything together.
Yeah, I've seen motions for extension granted weeks after the. They weren't filed on the last day either. When will the new courthouse be built, or is nobody gonna say?
It's looking like 25 August,
So the 2 years.
at least, and that's not taking into account delays for lovely hurricanes that hit Florida.
Yeah.
Where are they putting that one?
In St. Pete,
St. Pete, right?
right next to Mirror Lake,
Right,
across from the other court that's already there.
right. I read that.
Yes.
I don't know, personally, I like coming here. It's right across my office. I enjoy being able to get here in 5 minutes. I remember the days back where you fucking go, oh no, I have to go to Lakeland and just, you literally screech in screeching in as your case was getting called because you got the wrong court.
It's the people who appropriate the money solve differently.
Yeah.
At least, I don't think they've appropriated money yet for the 6th. To get a courthouse. At least y'all are getting one.
But it took a while.
Yeah.
That's it.
Yes, a lot of work by a lot of judges.
How long has the court been then moved from it's been like 3 years now, am I right?
No, well, the headquarters was there, but court was already here well before.
Yeah.
Well, I know that, but there was a point in time that there were some judges there and some judges here, and then there became a point in time when the Lakeland building got condemned and everybody moved in here. That's what I was trying to remember.
Yeah, Lakeland was still the headquarters as of last year.
But none of the judges were there last year, right? They were all in this building, I thought.
No, we had a couple that were still there.
Oh, really?
Yes.
Okay. I thought the building had been condemned for health
Well,
reasons.
no. So they had a building but the courthouse was condemned.
Oh, okay.
There was two different locations.
I see. I got you.
So the courthouse was condemned a while ago, asbestos and.
That's what I was trying to remember how long ago that was. Because I remember that, generally the newer judges were over there in Lakeland and the more senior judges were here in Tampa. Because most of them preferred to be here, was my sense.
Yes, and due to the redistricting, a judge moved, a judge decided to stay, so.
Right, no, yeah.
So
I think he only lost one judge that way.
that Judge Star just stood
Stayed
the sixth. A lot of moving pieces, a lot of work done by a lot of different people.
Sure. Be nice when the one over there is sinking it's done, even if it's a little longer drive. What is, anybody know what Stetson's gonna do with all the space? No,
Don't know.
because it won't be used at all, right, at that point. I mean, it's gonna be a complete move, as far as you know.
For us, yes.
I mean, there's not gonna be any, no one's gonna be lingering here.
Yeah.
There's gonna be a lot of space that the law school has all. the
Yeah,
time.
so you got half of the second floor and all the third floor.
Wow.
Hmm.
I remember when this building was built. Maybe we'll start actually maybe remodel and hold some more classes here.
Possibly, I don't know what Stetson's plan is, but once we move, everyone goes.
Right,
Yes,
well. Do they have, that's fine. I mean, the main campus is over in St. Pete for Stetson, but I guess, what do they have, like night classes here for students?
they do, yes. They also rent out the space as well, so they have. Businesses have meetings here during the week sometimes. Most of the classes are held at night, but you have different hospitals have staff meetings here in the classrooms up on the second floor. They use this space here, so there's other government entities that use this room as well, so.
Right. You know, this is a classroom, it's a good size. Bigger than. A lot of the courtrooms you're in.
All rise. This court remains in session. You may be seated.
Well, Bill, good morning. Yep. Good morning. We're here for the final case on the docket, Gowan Care versus Schmidt. We're ready when you are.
May it please the court. Jason Azar on behalf of Gowan Care. We are the petitioners in this action where we have filed a petition for writ of certiorari stemming from the lower court's denial of our motion to dismiss for what we felt was the failure of the plaintiff to comply with Florida's medical malpractice pre-suit statutes. And as the court is aware, there are a multitude of issues that have been presented in the briefs. I feel the main issue, unless your honors are going to.
I've got one preliminary question.
Yeah, I figured.
Can we address the elephant that walked into the room a couple months ago, the Carmody case out of the Supreme Court?
Yeah, the Carmody case is that was an interesting one, wasn't it? So I read the case again last night, trying to understand what the Supreme Court did. And we've had some arguments in my office about what the impact of this case was. And essentially, I think what the Supreme Court did was said that the trial court in that case went a little far afield of what they can do in determining whether a expert is qualified to render an opinion in that case. Because in the opinion, it says that the court conducted discovery on the issue and took depositions on the issue. And I've never seen that in all the years I've been doing this with the medical malpractice. I've never seen any judge act at the circuit court level actually do any type of discovery on the
In
issue.
fairness to the circuit judge, though, these qualification issues, the way they get teed up and the way they get brought before the circuit court, and the way they end up coming before us and served, you can kind of understand why, right? I mean, these things can get really deep in the weeds about levels of qualification, and who can opine upon what and upon what defendants.
And before I go any further, Judge Lucas, I'm sorry, I'd like to reserve 5 minutes for rebuttal. Thank you, Judge. You know, you're right. And I think when you look at what qualifies a expert in order to come to pre-suit, before we had the statute that said same or special, same or similar, and that really opened the doors to a lot of discussion. And again, coming in with a cold record, when the legislature took out the similar and said it's got to be the same specialty, I think it kind of cut it down. But if you look at the four corners of the NOI and the expert's opinion, you can generally tell if they're qualified or not, if they are the same specialty. You're going to have those types of cases where, well, he's a neurosurgeon. I think it's one of the cases cited. You're a neurologist. We both work on feet. Well, you're the same. We don't have the same training, but we do the same thing. That's where it kind of maybe get into a little bit of the muddied waters. But I think overall, generally, 90% of the time, just looking at the circuit court, just looking at the affidavit, the CV can pretty much tell if it's the same specialty or not. I mean, you know, we're not talking about the cases that come before your honors aren't the cases where you have a podiatrist trying to render an opinion as to a emergency room physician. You know, you don't have that. It's more those close calls where I think, and I think in the commodity case, what happened was you had one of those close calls, and the circuit court decided, look, I need to expand my review and what I can do, and on and allowed depositions, which again, I've never seen in the pre-suit context of an expert. In fact, most of the case law I read says that's absolutely not permitted. You don't really get to the deposition until such time as you're doing your motion for determination after the same expert has been deposed once suit has been filed. That's kind of where you see that, not in the beginning stages like where we are here. And I think what the Supreme Court did was recognized, similar to what they recently did with punitive damages, was recognized, look, we need to be able to review this. There's got to be some way of reviewing the qualifications a little more expansively than what we have, similar to what they did with punitive damages, where it was only allowed to say, okay, did you follow this format? We can't really look at the evidence. I think what the Supreme Court is saying now is we need to be able to give the DCAs and the Supreme Court's the ability to look at this qualification a little more closely on those cases that are close. So I think that's why you have that case saying, well, it wasn't permitted then, we're going to amend the rules and we're going to do it now. And I think that's the right decision. I think that the protections afforded by the Medical Malpractice Act are that important. And you get to a point, and I think this kind of dovetails into what I think is the real issue here today. The plaintiff's bar, when filing a claim for medical malpractice, are of the opinion, I get one expert. If I get one expert to say there is medical negligence, that's all I need. I just need one. I don't care if I'm suing 10 doctors, I just need one. And I kind of brought this up in my petition. You know, you can theorize the situation where you have a patient come in to a hospital in an emergency room setting, sees an ER doctor, ER nurses, has surgery for some reason, and then receives physical therapy from a physical therapist at the hospital. And somewhere along that line, there's medical malpractice. Under the theory of the plaintiffs, in this case, the one practitioner theory, they could say, well, we have a medical malpractice claim against the physical therapist, and that's all I need to do to get through the courthouse door. And that's not really what the Medical Malpractice Act says. And it's not really what it stands for, because you have different providers, and all of those providers need to be afforded the same protections of the Medical Malpractice Act. Do they do the investigation? They need to know that they may be on the hook.
Does it make a difference that would bring a claim directly against the provider as opposed to bringing a claim against the hospital vicarious liability.
And that's the second big issue on this one. And we say no, there shouldn't be. Because if you're suing a hospital, you can't do indirectly what you can't do directly. If you're going to sue the provider, you have to file the Medical Malpractice Act. Why shouldn't those protections apply to a hospital as well? If you're going to say, in my scenario, well, we think that everyone took part in this malpractice, from the ER doctor to the ER nurse, to the nurses on the floor, to the physical therapist. If you're going to sue a hospital for vicarious liability, it shouldn't be, well, we get to pick one and we're good. No, what should happen is you should put that hospital on notice to say, we intend to sue you vicariously for all of these providers, and have an expert review and say whether or not there is a claim for medical malpractice. Because the flip side of that, Judge LaRose, is if they don't, then what are we thinking here? Okay, well, maybe they had an expert review everything, and that expert, he really doesn't think that there's medical malpractice from the ER. The ER doctor did everything they could. But just doing pre-suit as to the physical therapist. Now, we don't know if there was an investigation done. We don't know if there was a review by an expert for those other providers. So it shouldn't matter. It shouldn't matter that it's a hospital. And I'm fairly confident in the Mann case, this court essentially said that. They had a case where it was TDH, and the amended complaint came in, and it was vicarious for a hospital. And this court said, no, you have to pre-suit everyone. You have to give everyone notice. You have to give the hospital notice of everyone who's coming in here. Everyone who's going to be sued, you have to give them notice. Now, in the response, the petition response, I know the argument is that, well, we don't have to tell you everything. We don't have to try our cases, essentially. We're not saying that. We're not saying you have to try your case. But what you do have to do is tell us who we're responsible for. Because there may be a situation where we think that one provider, there may be a good claim, and we want to avail ourselves to the protections of the Medical Malpractice Act, but maybe there's some that we don't. And what is the hospital left to do? Guess? We have to guess on who's going to be sued and what they're going to be sued for. And I think those are the real issues here. This court has consistently held in multiple cases, including the Jackson case.
I hate to go back to the original question.
Yes, sir.
But I'm still troubled by Carmody, because you dovetailed into the policy issues and what your position is on that. But the whole of the case is that we can no longer use certiorari to review qualification issues.
Well, we're not really asking for that. In essence, we're not. Part of our issue, part of our argument is a qualification argument,
Yeah.
but part of ours is you didn't even do pre-suit. Now that's a completely different animal. We're saying you did not pre-suit the critical care specialist. You did not pre-suit the physician's assistant at all. That doesn't get touched by.
PA is not named as a defendant.
I don't know. These were all vicarious.
Right.
These were all vicarious. So again, going back to what Judge LaRose said, they're trying to do indirectly what they can't do directly.
And that, that may be, maybe call your legislator. I don't know.
Yes.
But on the issue of the subject compliance with qualification, can we agree Carmody's kind of has put that off? That it's resolved. We can't reach that anymore.
Your Honor, I don't know the answer to that question because it's procedural. So where it's procedural, do we go from the day of the order? Do we go from the day of the petition, or do we go from today? Because the court is saying it's procedural, which means we go from the time it's being decided. Does that mean now this court can open the door and absolutely look at the qualifications? I think there's an argument to be made there. I don't know the answer to that question, but I think if you look at it, there's a good argument on either side.
Color me initially skeptical to that, but I'll be open to persuasion. But
well,
I'm not really sure.
Again,
are two different. I mean, this is how jurisdiction gets, and those are just two categorically different animals. Certiorari and a non-final order appeal. And there's no indication before the Supreme Court that they meant for the simultaneously adopted rule amendments to be retrospective implication.
I understand your point, Your Honor. I do, and I struggled with that myself. And in trying to prepare for this today is to say, okay, well, if that is true and that is correct, does this entire appeal go away? And it doesn't, because again, the qualifications of the expert are one aspect of the arguments that we're raising. There's also the argument of you didn't comply with pre-suit at all. And I don't think Harmony touches on that. And with that, I believe I have just about 5 minutes left.
You've got, excuse me, you've got 8 minutes left. That includes your rebuttal time.
Thank you. Okay.
So I have a question
Yes,
for
sir.
you though, because there are certain things about the TGH case I'm not certain where I'd land on, but here's the question I have. For purposes of pre-suit, you have a viable claim against the hospital. Your client has moved to dismiss, saying insufficient. Could this have been handled, or could this be handled as in some fashion, a motion in limine saying they can't bring in any of this information about these other people? And if the trial court says, no, they can bring it all in, I think there was sufficient pre-suit, I've already ruled there's sufficient pre-suit, wouldn't that be reviewable on appeal post-judgment?
So you're saying in the hypothetical context of a motion in limine, we're going to allow the discovery, we're going to allow everything.
Based on what the trial court has done to this point, if we feel that certiorari jurisdiction simply doesn't lie at this point in the case, would you be precluded from filing a motion in limine saying, Judge, we know you ruled against us on a motion to dismiss, but this information shouldn't come in because the experts never really identified this person?
So I have a few answers to that, if you'll indulge me for a moment. The simple answer is no. There's nothing to stop us from doing a motion in limine and having that raised on appeal. However, what that scenario does is the same scenario as if we wanted to file a motion for summary judgment. Let's just suppose that the plaintiffs in the case use the same expert. We're able to go and depose that expert and say, hey, did you look at this? Did you look at the critical care? Did you look at the physician's assistant? No, I didn't. Now we can file either another motion for determination or a motion for summary judgment. Again, denied. We can do that on a plenary appeal.
And if the doctor says, yes, I did, that also gives you an argument that they didn't put us on notice when they should have, when the doctor himself or herself.
Yes, exactly. But what do those two scenarios do? Those two scenarios negate the whole reason why the courts allow certiorari in these types of situations, because if there's no pre-suit, there should be no case.
But there has been a pre-suit and there is a case. The case goes forward one way or the other based on at least what the expert opined in writing.
But again, you're taking away the protections of the hospital's protections under the Medical Malpractice Act. We're allowed to say, okay, there's nothing.
Now that we know there's this other potential liability,
right,
we really do want to settle, as opposed to,
or we want binding arbitration. And there are protections where if we offer arbitration and it's denied, there are protections for that. And your scenario takes those away. That's the entire reason the courts have said prior to this, certiorari lies for these types of situations, because if we don't address this now, the protections of the Medical Malpractice Acts are nullity. They're not going to do anything. They're going to be ineffective. That's why there's no way to remedy on appeal. We're going to make you go through the entire lawsuit and say, oh, you shouldn't have had to worry about the nurses. You shouldn't have to worry about critical care. You shouldn't have had to worry about that physician's assistant, but we've already have. This case, and this is my last point, and I'll save the remainder for rebuttal. In this case, one of the arguments raised, which goes to your point, well, the hospital's in it already. You're right, the hospital's in it already. We're already in vicariously for a few of the doctors. But again, the point is, where are the protections? We need to know who we are required to defend, who we may be on the hook for, so that we can make that informed decision. Without the investigation, without knowing, we can't do that. And that's why we believe that the lower court erred in denying our motion. And I'll reserve the remainder of my time for rebuttal. Thank you, Your Honors.
very good. You'll have your 5 minutes, and Mr. Gowdy, you'll have 20 minutes.
Good afternoon. Good morning, may it please the court. Brian Gowdy on behalf of the Schmidt family. Your Honor, I'm going to make, there's 3 points that I'm going to try to make, but really the first point, which Judge Lucas has already alluded to, is where you have to stop. You don't have to do anything else. But my main 3 points are: 1, under Carmody, this court cannot review this case. And I'll go more into that in a moment. 2, under the plain language of 766.2032, and not all the policy arguments we just heard for the last 10 minutes, the reasonable corroboration is to the named defendant, not unnamed providers. It is to the named defendant. And therefore, there is no requirement in the plain text of the statute to corroborate every single possible instance of medical negligence. And I'll go more into that. Number 3, if we get there, which I don't see why you need to, because this is a pretty complicated steps on how to read these 4 statutes together. Non-Florida physicians, like the 2 experts we had here, are allowed to testify on medical support staff. But let me go back to number 1. In the Jackman case, which Judge Lucas, you were on the panel, it was per curiam, the court said this, and Jackman's going to come back because it went up, you certified it, it's hanging on, and once everything gets cleared out from Carmody, you're going to see it again, I suspect. But this court has consistently held, this is what the panel wrote in Jackman, this court, meaning the 2nd District, has consistently held that denying a motion to dismiss where pre-suit corroboration, expert corroboration is insufficient is a departure from the essential requirements of the law. And you cited the Mann case, which Judge LaRose was on. In Carmody, that was directly overruled. The Florida Supreme Court made it clear that it agreed with the 1st District, and the result got there with a little different rationale, but said that the sufficiency of an expert affidavit is not susceptible to certiorari review because it cannot be a departure from the essential requirements of law. Now I want to read the order that you're reviewing. It was made orally. There are sufficient findings here. And then the judge said in her written order, as stated on the record, I'm going to find the qualifications of Dr. Levin, or at least facially sufficient to give the opinion. That's the order they're seeking review of. So, and then she says later on, the judge, I think the affidavit is sufficient. I'm also going to find the language in this pre-suit, I think she meant to say affidavit, is sufficient. Sufficient to the point to include the staff of Brandon Regional Hospital and its agents. So we now have most of, and to my friends, you know, when the reason I asked for oral argument, I figured Carmody would come out done after briefing, and it did. All the authorities he relied on in his petition, Mann, Jackman, were overturned by Carmody. So you can't decide this case. It's that simple. And unless the court has any questions about the effect of Carmody, I'm going to go on to my other 2 points. But which might help you on a future case, because I think you're going to see these issues again and again. I just heard policy argument after policy argument after policy argument as to why they need to know about every single provider's negligence. Keep in mind, in many medical malpractice cases, when you go into a hospital, so I'm sure everyone's had that experience, you get touched by multiple providers. In this case, it was probably 8 or 10, if not more, providers. And of course, so I say all that if you want to get to the policy arguments, but let's just stick to the text of the statute, and it's 766.2032. I got too many papers here. Subsection 2. This is what it says in the statute about the pre-suit investigation. The claimant shall conduct an investigation to ascertain that there are reasonable grounds to believe that 1, any named defendant. Now, I've read Jackman, I've read Mann, and nobody pointed this particular language out to you in those cases. It doesn't say any provider. It doesn't say anybody for whom the hospital could be held liable. It says named defendant. We have one named defendant here. It's the hospital. We've not named the physician assistant. We've not named the critical care specialists who we don't even know their names yet. We have not named all the providers. We don't have to. And it says in the statute, we have to reasonably corroborate there's reasonable grounds to believe that any named defendant in the litigation was negligent in the care or treatment of the claimant. As you pointed out, Judge Silverman, we've done that. It's undisputed. And you also have to show the negligence resulted in injury to the claimant. There is no requirement in this statute to state every instance of negligence. There was never a meaning, and I laid it out in my response. The corroboration requirement is to ensure that this is not a baseless lawsuit. It's not a substitution for the rules of civil procedure and the complaint, or for section 57105. And we, at the beginning, limited our claims based on what we knew in pre-suit, but I see this time and time again in medical malpractice cases. You get into discovery, you learn additional facts that you didn't know, and therefore it could be that you plead additional instances of medical negligence against an individual or corporation. For example, we cite the Davis case from the 5th District, where originally the allegation was that the surgery was negligent. And then at some point in the lawsuit, you realize it wasn't just the surgery, it was the post-surgical care that was also negligent. And the standard rules kick in. And as long as you're not bringing in a new defendant who didn't get the benefit of this isn't a new defendant, it's the same defendant. You're allowed to do that just like any other civil case. The other case that's out there is the JFK Columbia case from the 4th District. In that case, there was a negligence by the OBGYN a day before the patient went to the emergency room, and there was negligence in the emergency room. The pre-suit affidavit dealt with only the emergency care. And the 4th District said that that was sufficient because the purpose is not notice. I heard this again and again and again. If you go back through all the statutory history, it's corroboration. That's why we have the affidavit. They get the notice of intent. That's a separate document. So there's just no requirement in the text of the statute. And I will say, in all candor, I litigate this all around the state, and in this district, based on Jackman and Mann, I hear the same argument. It's bare, and what we hear is the same thing. They go and they dig out the complaints that aren't in the opinion, and they try to say that the 4th District is wrong in JFK and the 5th District's wrong in Davis. And at some point you may get to that, have to deal with that. I will point out this court in Bonatti, which is the first case they cite, and which started all this, Bonatti cited Davis and actually said exactly what Davis has cited all around outside the 2nd District for, which is that you don't have to plead in the pre-suit affidavit every instance of medical negligence. And this court said that in Bonatti. But I'll admit that since then, these decisions, Mann and Jackman, seem to go elsewhere. At this point, I think both those decisions are no longer good law in light of Carmody, at least on the procedural context. I don't know how much time I have left.
11 minutes.
Okay. If I've gone over the first 2 issues, if the court doesn't have any questions, I'd like to tackle the last one. And if it would be all right, and I have one for opposing counsel, because this is so confusing, I kind of wrote this out, and if I could approach and give this to the clerk, would that be all right?
You know, I had a note about Bonatti, and I wanted to clarify one thing
Yeah.
about it. In Bonatti, wasn't there a defendant who was actually named for whom there was no corroborating affidavit?
Bingo.
Yeah.
That's so, and we wouldn't disagree with that. We're not disagreeing with the holding of Bonatti.
It was a party.
Right. You can't, if we, just for example, in this case, the physician assistant who's unnamed and is not a party, but for whom we say the hospital is liable. If we brought him into this case, we would have to have an affidavit that covered him. Now, we think these affidavits do, but that would be what he's entitled to. It's not it's the named defendant. Okay, it's not every claim, doesn't say that here. It's nowhere in the statute. So you're right, with Bonatti, if we brought the physician assistant in, we would have to, for his rights, we would have to comply with this. And it would only, obviously, we couldn't hold the physician assistant. He was a neurosurgical physician assistant. We couldn't hold him liable for what, the emergency people did in another part of the hospital. At least not necessarily, right? We have to focus on whether his standard of care. So,
well, I want to ask you the same basic question I asked the hospital's lawyer, which is, well, I want to intro it. So the introduction is you have vicarious liability, which is based on an unnamed defendant's or one unnamed defendant's, potentially one unnamed defendant's conduct. And it is troubling that Bonatti doesn't really address it. And I don't think any cases directly say, well, vicarious liability, as long as you've named the hospital, you don't have to worry about others. And maybe you've got a case that directly deals with that. But I'll go to the point of some of these issues can be resolved on appeal if information comes in for which the hospital would have had no clue that there was potential liability for a particular non-named party, non-named individual conduct.
right. So I heard your question to him, and I would agree. I mean, I don't think we need to get here either. We make the irreparable harm argument, which is separate from departure from essential requirements of law. And I agree with you that these things could be corrected on plenary appeal. I think I would I would disagree with some of the premise of what you're saying. The primary vehicle for getting notice is the notice of intent, but even under that, it's not that you get notice of every provider or every instance. The way you would get notice before trial is through the complaint. We go back to the good old rules of civil procedure. And the pre-suit is an exception to the rules of civil procedure, but you've got to show where in the statute you fall under that exception. And, I hear all this like, oh, this is going to be terrible. Well, it's the same rules that everybody else in the state follows. And the reason that plaintiffs' lawyers don't put these in the initial complaint is they actually are carrying out their good faith obligation of just not naming every single provider under the sun. And so now we're hearing, because we don't do that, oh, that's it. Once you're done with pre-suit, you can't add any other instances of negligence. You can't name any other providers. I'll just tell you, I've done a lot of these cases too. And also about the discovery, I see it all the time. I completely disagree with my friend on that. In fact, this court's case law, Holder and the Williams v. Oakland case from the Florida Supreme Court, talks about you need to have evidentiary hearings for these issues. Well, if you have evidentiary hearings, what do you think you have before? You have depositions. So I'm not sure, maybe they aren't asking for them, but in the cases I handle, I see these. And the point being that is that as far as the pre-suit, Your Honor, it's only to ensure that there's not a frivolous lawsuit or a baseless litigation that's filed against the defendant. And they've conceded that hasn't happened because they're not challenging the affidavit. So I'm sorry, I don't know if I hope that answers your question.
Well, considering there were multiple parts in different directions, we did fine addressing it.
Could I hand you this? I'll try to be quick with it, or if not, it's
like a demonstrative.
It is a demonstrative.
Back my child.
This goes to what I don't think the court's going to get here on this case because of Carmody, but there's a lot of confusion.
It won't be for lack of demonstratives.
this deals with, you see, in a lot of these cases you read, you'll see this it came up in Mann, where you have, usually you have out-of-state physicians as expert witnesses. I think you can see why that is. It's difficult to get a Florida physician to testify against another Florida physician. And so there's a real question though about their ability to testify, an out-of-state physician to testify against what I'll broadly call medical support staff. And that's nurses, nurse practitioners, anyone who's basically not a physician. Okay. And the statute that authorize a non-Florida physician to testify here is 458.3175. And what my friend did in his petition, and he did again in the reply, is he skips the bold language that I just put you. He doesn't quote it. He just acts like it's not there. And so what this statute says is that an out-of-state physician can testify in a Florida court an out-of-state physician is authorized to do 3 things in Florida court proceedings. The last one we're not here on, can testify in criminal child abuse and neglect cases. The next 2 we are here on, but we're not here on B. But that's what he quotes in his petition. That's what he quotes in his reply. B deals with testimony at trial. A deals with the verified medical expert opinion as provided in 203. And then to get through this, it's just like each statute cross-references another one. And that's why I've laid it out on this piece of paper. But what A tells you is that an out-of-state witness, an out-of-state physician, he's authorized to provide a verified written medical expert opinion as provided in 203. That's the pre-suit opinion, which is different than the trial testimony. And in these cases, we often see you might have one expert at pre-suit, and then you have to get multiple other experts by the time you get to trial. Or you might not even use that pre-suit expert for whatever reason. So then if you go to step 2 here, what it says is, this is the corroboration of, this is pre-suit. It has to be a verified written medical expert opinion as defined in 2026. Jump to 2026. It has 3 requirements in there. Regularly engaged in practice, holds a healthcare professional degree from a university or college, and meets the requirements set forth in 766.102. Now, my friend will latch on to that last thing and say, see, if the qualifications are the same for the pre-suit opinion as they are for trial testimony. But it doesn't cross-reference 458.3175. It cross-references 766.102. And if you go to 102, and I haven't been able to put it all here, you go to the main subsection is subsection 5, and there's 3 options under there. Now, we heard a lot today about same specialty. That's not at play at this case at all. Same specialty deals with physicians. We're not here with physicians. We're here with a physician assistant and a critical care specialist. That falls under 5C. And go read the Carmody opinion by Justice Coriel. He points this out because we heard the same argument there. In 5C, they left in the words same or similar health profession, They left that in 5C. So why we hear arguments about same specialty when we're not here on a specialist? 5A applies only to specialists, a specialist like a neurosurgeon. I'm not sure, but 5C is what applies, and they haven't challenged that. What they're challenging is the other part in subsection 6. Okay, and Carmody, it's dicta, but I think it's right. And frankly, I will tell you, there's a part of our response on page 42 that I don't think is correct in light of this dicta. But if you go to page 43, our alternative argument lines up with this dicta. You have to meet both 5C and subsection 6. So what does subsection 6 say? It says a physician licensed under chapter 458. Well, go back to the top. an expert physician who's from out of state gets a certificate under chapter 458. He's licensed under chapter 458 to do three things: testify in cases during criminal child abuse and neglect, testify in medical malpractice cases at trial, and provide the verified written medical opinion. That's the correct statutory analysis. I don't think you have to get there, because whether you agree with me or not, there's no way this trial judge departed from the essential requirements of law, because there is no case out there addressing this. I've looked through every case, including it came up in Mann, I can tell Judge LaRose. It doesn't get addressed because these have all come up in certiorari. Now that we're going to have appeals, they will. My last point that I don't want to miss, I heard this.
And you'll need to make it a quick point because.
Okay, well, our second notice of supplemental authority cited the Sarasota County case that Judge Lucas and Judge Silberman were on the court. In footnotes 4 and 8, you make it very clear that when there is a new rule of appellate procedure, it does not apply to the certiorari proceeding that's pending. In that case, the Sarasota County case, I provided as my second notice of supplemental authority. We were dealing with the new rule of punitive damages. What matters is what was the rule in effect on the date of either the order or at the latest when the initiating document is filed. So here the petition. When the order was entered and when he filed my friend filed his petition, we were under the old rule of appellate procedure. So this court's already answered it. And that Sarasota County case, I did not submit second supplemental authority. Another panel of this court, let me grab it real quick. And I'll file this afterwards. Beck v. Wright, 353 Southern 3rd, 664, adopted your footnote 4 and 8. So there's been two panels that have recognized that you do not apply these new rules of appellate procedure to pending extraordinary writ petitions. And with that, and without any further questions, we'd ask the court to deny or dismiss the petition.
Thank you, Mr. Chairman.
May it please the court. In Bonatti, this court specifically stated the Medical Malpractice Act defines investigation to mean that an attorney has reviewed the case against each and every potential defendant and has consulted with a medical expert and obtained an opinion from said expert. Counsel says you don't have to do that if you're suing a hospital. He's creating a distinction between what has to be done as to a party versus a hospital. Because his theory is if it's a hospital, I only have to name one. That's all I have to do. Because the statute says any defendant. Their reading is any one defendant. I'm good. But if it has to apply to any named defendant, if it's an individual, why doesn't the same analysis apply to a hospital? Does that make sense? Does it make sense that a plaintiff could sue a hospital and do a pre-suit as to any one doctor they choose? They pick and choose and then sue everybody. Because under his theory, under the plaintiff's theory, I could go in and Medical Malpractice Act, we don't need to worry about it. I'm going to pre-suit the nursing staff and file my suit against all of the emergency room physicians. That's what they're saying we can do. And that's not what the Medical Malpractice Act says. If you look at this court's opinion in Jackman at page *3, and it's the beginning of head note 4.
Fair to say Jackman, I mean, you had two concurrences, a per curiam opinion that I think I was the only one that, because somebody had to. And even the per curiam opinion sounded awfully reluctant about using certiorari for what you're
Well, and again, I'm going to get to that, Your Honor. That's why I'm bringing this up. It says our court has expanded the scope of certiorari to address not only a plaintiff's facial compliance with 766-2032, but also the quality of a plaintiff's compliance.
Right. And
We're
when you
making-
cite, if I remember, is like, even when we disagree with, what somebody said, we're bound by the panel to do it. And that prior panel is now gone. So,
But we're not only arguing the quality, we're also arguing the facial. And that's still good law. That's still available because at the end of the day, there was nothing in any of those notice of intent, nothing in those opinions that the experts rendered that said anything as to these providers. They were silent. So essentially what we're looking at is I can file suit against the hospital. I don't ever have to pre-suit them. I can name them a month before trial, say, oh, I'm going to bring in this party too. Now, counsel says, oh, well, we'll never be able to get beyond pre-suit. That's not true. We all know that the law says that you have up until the expiration of the statute of limitations to complete pre-suit against any other party you want to name. That would apply just as equally to a hospital. If you come through and there's someone in the records or you didn't find someone in the records, because I think we have two situations. You have a situation where the person is named in the record, which is the situation here, by the way. And you have a situation where we might discover that person later on. You can cure that. All you need to do is initiate the pre-suit to that new party you learned during discovery. So we're absolutely not saying, no, you get it in pre-suit and that's it, you're done. Because I don't think that would be a fair reading of the law. Just as I don't think the plaintiff's reading of the law is correct. It shouldn't be for a hospital. I get to pick whoever I want, any claim I want. And that's enough. That's enough. Because again, what is the basic ability? Why do we have the Medical Malpractice Act? To kind of allow people to look at these claims, investigate, like the Benatti court said, and determine whether we need to go forward. Very quickly addressing the demonstrative exhibit. The expert certificate, and the law has been clear on this, the expert certificate is to allow an expert from out of state to opine as to a physician, because again, they are the same specialty, they're the same thing. There's nothing indicating that a doctor from Georgia would have any idea about how nursing staffs in Florida work, how physicians assistants in Florida work. That would have to be in their affidavit, say, I have knowledge of this. So what counsel's saying is, well, we're going to break this up into two separate things. No, the expert certificate is only for physicians, and that's very clear in the statute. Again, we would ask that, last point on the jurisdictional issue. Again, I do agree that Carmody may have taken away the ability to look at the qualifications, but at the end of the day, again, we're looking at facial failure to comply with pre-suit as to these providers, because again, there is nothing in those notices and nothing in the affidavits. Thank you, Your Honors.
Very good. Thank you very much. Thank you both. That concludes the oral argument session for today. We appreciate your being here, and we are adjourned.
All rise. Thank you. Travel safely.
Thank you. Great job.
Yeah. Meet you in person.
Yeah, finally, huh?